The meeting scheduled for Friday, May 24th, 2024 for the Committee on Rules and Judiciary has been called to order. First, I'd like to acknowledge my committee members who are present and say a blessed good afternoon to the people of the Virgin Islands, invited testifier, the listening and viewing audience, and the legislative staff working this meeting today. My apologies for stepping out to the norm to begin today's meeting at 12 o'clock p.m., which is unusual. On a somber note, I wish to send my best regards and condolences to the McIntosh family on the passing of their patriarch, Rodney McIntosh. As many of you know, today is the graduation of St. Croix Central High School, hence the reason for the delayed commencement of this committee meeting. During this past week, I attended countless promotional ceremonies of the elementary and junior high schools here on the island of St. Croix today. Today, I also attended the graduation of the St. Croix Central High School to the unstoppable, undaunted, elite CHS class of 2024. I extend congratulations to you. In advance, I want to congratulate the graduates of St. Croix Educational Complex of the elite class of 2024. My message to parents, teachers, administrative staff: thank you for providing our children with every opportunity to shine. They may or may not realize it, but when reality hits, they will be forever grateful. I want to express my pride as I observe many of you who make the sacrifices throughout the educational journey of these youth. These children could not have done it without you. Your selflessness and determination have not gone unnoticed. The students of the John H. Woodson Junior High School struggled but adapted to several transitions during this school year. Students at the Pearl B. Larson and St. Croix Educational Complex endured and overcome the obstacles associated with heat wave and lack of air conditioning. The St. Croix Central High School students struggle whenever it rains. Despite of all the challenges, each school exhibited pride, and you guys did it. Congratulations. And a special congratulations to even the adult side where they had the congratulations last night for those who had challenges but made the sacrifices for adult ed. So special congratulations to them. To all the graduates from kindergarten through 12th grade, your journey in life is just beginning. Your futures are so bright. Be wise, make good choices, stay clear of any circumstances that can derail you from achieving your goals. You got this. I want to say a special condolences. This morning, as we awoke, the Virgin Islands legislature received news that there was the passing of Pamela Richards. I personally knew Pamela Richards. I had the opportunity to work with her at the Department of Human Services. Today, I even jolted my memory and remember that one year I was vending and I was late, and she offered her tent to me and said, K-Pot, you could vend with me to sell Dee's Island potpourri. She was always involved in this community, from Department of Tourism, where she shined as the commissioner, being the executive director of the legislature, I think from the 29th legislature to the 33rd, if my numbers are correct. I just want to send my condolences, and I wish her family Godspeed. In the essence of time, let us proceed. Today, we have 4 blocks and 1 nominee and 5 bills. At this time, I will direct the clerk for a roll call.
Angel Bolquez Jr.,
Present.
Senator Bolquez Jr., present. Senator Diane T. Capehart,
Present.
Senator Capehart, present. Senator Kenneth L. Gittins, Senator Gittins, absent. Senator Maurice C. James, Senator James, absent. Senator Franklin D. Johnson, Senator Johnson, absent. Senator Carla J. Joseph, Senator Joseph, absent. Senator Milton E. Potter,
Here.
Senator Potter, present. Madam Chair, you have 3 present, 4 absent.
Madam Clerk, are there any correspondence to be read into record?
Yes.
May proceed.
May 24th, 2024, the Honorable Senator Diane T. Capehart, Chairwoman, Committee on Rules and Judiciary, 35th Legislature of the Virgin Islands, Capitol Building, Charlotte, O'Malley. Senator Franklin D. Johnson's tardy letter. Dear Senator Capehart, please be advised that I will be late in attending the Committee on Rules and Judiciary meeting scheduled for Friday, May 24th, 2024. My sincere apologies for any inconvenience my delayed arrival may cause. I look forward to joining the meeting shortly. Thank you for understanding in this matter. Sincerely, Franklin D. Johnson, Senator, 35th Legislature. The Honorable Diane T. Capehart, Chairwoman. Letter of absence for Committee on Rules and Judiciary meeting. Dear Chairwoman Capehart, please accept this letter as a formal notice that I will be absent from the Committee on Rules and Judiciary scheduled for today, Friday, May 24th, 2024 at 12 o'clock in the Fritz Lowetz Legislature Conference Room on St. Croix due to a prior engagement. Kindly be sure to forward all documents and information shared at today's meeting to my office. Thank you in advance for understanding. Respectfully, Carla J. Joseph, Legislature Secretary. Honorable Senator Diane T. Capehart. Dear Senator Capehart, I do apologize that due to a previous commitment, I cannot be present at the Committee on Rules and Judiciary meeting today, Friday, May 24th, 2024. Kindly excuse my absence. I regret any inconvenience my absence may cause. Thank you for your understanding. Kind regards, Maurice C. James, Senator, 35th Legislature of the Virgin Islands. That's the end of your correspondence.
Thank you,
Chair.
Madam Clerk. Please mark Senator Carla Joseph as excused. Senator Franklin Johnson as excused. And at this time, the Committee of Rules and Judiciary is in 5-minute recess. The Committee on Rules and Judiciary is out of recess. At this time, I would like to acknowledge non-committee member, Senate President Novel Francis. Thank you for your attendance today. Madam Clerk, if you can please read the agenda into record.
The Committee on Rules and Judiciary has scheduled a meeting for Friday, May 24th, 2024, in the Fritz E. Lewis Legislative Conference Room, St. Croix, Virgin Islands, to consider the following nomination and bills. Block 1, Governor's nomination of Jamila L. Christopher, Representative of Department of Tourism, Virgin Islands Cannabis Advisory Board. Block 2, Bill number 35-0121, an act amending Virgin Islands Code, Title 4, Chapter 29, Section 482, and Title 5, Subtitle 1, Part 5, Chapter 61, Section 660, increasing jury and witness fees and allowances, respectively, sponsored by Senators Novell E. Francis Jr. and Diane T. Capehart. Invited testifiers, Regina Peterson, Administrator of Courts, Judiciary of the Virgin Islands, Attorney Marjorie Whalen, President, Virgin Islands Bar Association, Attorney Julie Tadman, Chief Public Defender, Office of the Territorial Public Defender, Attorney Ian Clement, Acting Attorney General, Office of the Attorney General, Attorney Russell Pate, the Pate Law Firm. Block 3, Bill number 35-0174, an act repealing and reenacting Title 15, Virgin Islands Code, Article 5, Parts 1, 2, 3, 4, enacting Part 5, and renumbering Part 4A as Part 6 to repeal the Uniform Guardianship and Protective Proceedings Act and enact the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act, with amendments and for other related purposes, sponsored by Senators Novell E. Francis Jr., Angel L. Boques Jr., and Marvin A. Blyden. Invited testifiers, Regina Peterson, Administrator of Courts, Judiciary of the Virgin Islands, Attorney Marjorie Whalen, President, Virgin Islands Bar Association, Attorney Julie Tadman, Chief Public Defender, Office of the Territorial Public Defender, Troy Schuster, VI State Director, American Associate of Retired Persons, Attorney Tom Bolt, Uniform Law Commissioner, Attorney Ben Oziki, Chief Counsel, Uniform Law Commission, Avril George, Commissioner Designee, VI Department of Human Services. Block 4, Bill number 35-0030, an act honoring and commending Vaughn Benjamin posthumously for his contributions to reggae music in the Virgin Islands and the global communities, appropriating $45,000 to the Department of Sports, Parks, and Recreation for the design and construction of the Vaughn Benjamin Monument and naming the waterfront park west of the Marley Homes the Vaughn Akabeka Memorial Park, sponsored by Senators Novell E. Francis Jr., Angel L. Boques Jr., Carla J. Joseph, and Samuel Carrion. Bill number 35-0215, an act amending Title 23, Virgin Islands Code, Chapter 5, Section 457, Subsection A, Paragraph 3, relating to the contents of a firearm license to change the statement in a license, increasing the term of the license from 3 years to 5 years, sponsored by Senator Milton E. Potter. Bill number 350238, an act to confer peace officer status on qualified enforcement officers employed by the Government Employees Retirement System of the Virgin Islands, sponsored by Senators Milton E. Potter and Angel L. Borges Jr. Madam Chair, that's the end of the agenda.
Thank you, Madam Clerk, for reading of the agenda into record. At this time, I would like to acknowledge our first nominee that's before us, the governor's nomination of Jamila L. Christopher. Miss Christopher, I know you're on St. Thomas, so I would ask that you stand, and we're doing some housekeeping so we can do the oath. Raise your right hand. Do you solemnly affirm under penalty of perjury that the testimony that you will give this committee will be the truth, the whole truth, and nothing but the truth, to the best of your knowledge and belief?
I do.
Thank you. You may be seated. So, colleagues, in the essence of time, we will proceed. And I would have Ms. Christopher, I just state your name on the record, and then you may proceed with reading of your testimony into record. You may proceed.
Sure. Good afternoon. My name is Jamelia Latia Miller Christopher.
Welcome. You may proceed.
Thank you. Oh, I need my glasses. Sorry. Good afternoon again. Committee Chair, Senator Diane T. Capehart, ranking members of the 35th Legislature, and distinguished members of the Committee of Rules and Judiciary. My name is Jamelia Latia Christopher, and I am deeply honored to be presenting myself as a representative from the Department of Tourism for the Cannabis Advisory Board, representing under the esteemed leadership of Commissioner Joseph B. Bashelti. It is my understanding as a member of the board that my primary responsibility is to provide financial and marketing data expertise regarding the potential impact of the cannabis industry on the tourism economy of the U.S. Virgin Islands. I am truly excited about the opportunity to share my background and qualifications, which I believe make me an excellent fit for this role. I was born and raised in St. Thomas, U.S. Virgin Islands, where I grew up in a close-knit family. My parents, Andrea Fret Miller Shaw and Jean Miller, instilled in me the values of hard work, integrity, and community service. Their unwavering dedication to providing a stable and nurturing environment has deeply influenced my aspirations and commitment to public service. I am a proud mother of 2 children, my daughter Jide, 20, currently in college, and my son Dylan in middle school. My experience as a parent has further reinforced my commitment to creating a better and more equitable society for future generations. I pursued my undergraduate education at the University of Phoenix, where I earned a bachelor's degree in business management. It equipped me with a solid foundation in organizational behavior, strategic planning, and policy development. My passion for continuous learning led me to obtain a master's degree in human resource management from Southern New Hampshire University, which I honed my skills to design, implement, and evaluate policies and procedures that promote efficiency, equity, and compliance within any organization. My professional experience spans over 20 years. I have worked in various capacities, and my most recent from HR generalist roles to senior management in both the private and public sector. Throughout my career, I have worked with extraordinary teams in developing and implementing policies that align with organizational goals while ensuring adherence to legal and regulatory standards. This work has involved collaborating with diverse stakeholders, including employees, management, and regulatory bodies, to create inclusive and effective workplace environments. For example, my understanding of state policy that addresses anti-discrimination for medical cannabis patients, which are designed to prevent discrimination against protected class. Medical cannabis is currently legal in 37 states. In my current role as Director of Administration and Management at the Department of Tourism, I have oversight over financial management, human resource management, event execution, policy development, and compliance and risk management, ensuring that administrative and operational processes are efficient, resources are used effectively, staff are well managed, and the department remains compliant with all relevant regulations. Working in the tourism industry has given me a deeper understanding for the complexities involved in policy implementation and the importance of achieving sustainable outcomes. The Cannabis Advisory Board presents a unique and exciting opportunity for me to contribute my expertise to an evolving and impactful field. My background in human resources has equipped me with the ability to navigate complex regulatory landscapes, advocate for adequate practices, and facilitate shareholders' engagement, skills that are directly transferable to the work of the advisory board. If selected as a member of the advisory board, I shall be committed to supporting the development and implementation of policies that promote responsible cannabis use, protect public health, and foster economic opportunities for our territory. I envision a board that is proactive in its approach, responsive to the needs of our community, and dedicated to ensuring long-term sustainability for the cannabis industry in our territory. I believe my presence ensures that the interests and concerns of the tourism sector are taken into consideration when formulating policies and making decisions regarding the cannabis industry. Thank you for accepting my testimony, and I welcome any questions that you may have. And I look forward to serving. Respectfully submitted.
Thank you, Ms. Christopher. So first, I always like to give my thanks for individuals who are asked to serve on boards, commissions. Thank you for your willingness to serve. So, colleagues, we don't have a quorum as yet because some of my colleagues, as all of us here on St. Croix, attended the St. Croix Central High School graduation, but I didn't want to hold this committee meeting up. But colleagues, we would begin with our line of questioning in this order. Senator Bolquez, Senator Potter, and Senator Francis. So, Ms. Christopher, this is just like a big job interview. So, I know that you mentioned that you had never come before the legislature in rules to vet for a position. So, starting with my colleague on St. Thomas, we will have a 4-minute round, starting with Senator Bolquez. Senator Bolquez, you may proceed.
Good afternoon, and thank you, Madam Chair. Good afternoon, colleagues. Good afternoon to the listening and viewing audience. And of course, good afternoon to our nominee, Ms. Make sure I get your name right, Ms. Jamila L. Christopher. And thank you for your testimony, and thanks for putting yourself forward. You mentioned in your testimony that the seat on the board specifically requires a specific skill set that you're bringing to the table. So for me, I want to sort of emphasize on those areas of the skill set that you're going to be bringing to the table to help enhance the cannabis industry here in the Virgin Islands, as we have had sort of a false start, if I can use that statement. And what that means is that it's sort of like a slow moving process, even though we know how economically how it can benefit our economy in so many different ways. And I'm just hoping that we don't lose the opportunity, as on the national level, there's a lot of changes that are being made as we speak. And we just want to be able to capitalize on a lot of those opportunities. So we got to get the ball rolling, one would say. So I wanted to start off by asking you about community impact. assessments. You mentioned sort of briefly in your testimony. Section 19 VIC 777H mentions the need for community impact assessments. How would you conduct, as a board member, how would you help to sort of set policies to conduct these assessments to balance, community concerns concerning the industry growth? Yet we have not seen the industry move forward, but there will be push and pull. And as the policy making part of the cannabis industry, what are some of the ways that you believe we can try to do that?
So I believe as there will be significant impact for the tourism industry, particularly when places come online and they become legalization. So you have economic boosts for the territory. You also have new job opportunities for those entrepreneurs that may possibly want to go into business. And then you also have job creation that will come with that. And then you have increase in taxes. And those monies will go into fueling the territory, whether or not you want to use those funds to continue to build for infrastructure, or you want to decide to give some of those funds back to tourism to continue to boost the cannabis market. And you also have the opportunity for us, another impact would be to promote the destination. So that will put us on an international market.
Okay, very well. And one of the most important things I believe for many members of this institution is equity. And when we were working on the bill in the 34th, a lot of that came up. And I believe it is still paramount that equity must be put on the forefront when it comes to this industry. And how will you, as a board member, ensure that the cannabis industry of the Virgin Islands is promoted to have equitable access for individuals who may want to get into the industry?
Can you repeat the question? You said equitable. I mean, that would come from just having fair practices in place.
Mm-hmm.
And
enforcing them.
Yeah.
more, and that's where I want to go, because I know that enforcement has also been another challenge. The OCR, the previous director, came to this institution a number of times and expressed to us over and over and over that the enforcement. Madam Chair, if I may, please.
Senator, you may proceed. I'll give you an extra minute. I think I'll give all colleagues 5 minutes total. You may proceed.
I appreciate your leniency, Madam Chair. The previous director did want to make sure that we understood that enforcement was the top tier of what she deemed to be important at the time concerning getting the industry moving forward, because they needed to hire enforcement officers. So we want to make sure that disadvantaged communities or individuals who may want to participate or be a part of this industry have an equitable opportunity to do so. So, I was just trying to pick your brain in the sense of what you believed was some of the ways that we could try to make it more equitable for those individuals.
So you said underprivileged. So one of the things, I read an article, I think a few months back, and one of the things that the state of New York did for people that were incarcerated, they gave them an opportunity to be able to go into the cannabis field. I don't know if you guys saw the article. So that's one of the things, they were able to come out, start a business, and they gave them, I think it was a certain percentage of that class that was able to open a business. So that's one of the avenues or things that we can look at as a story of ways for the underclass and people that has been incarcerated that will still be able to come out and be able to be productive in our community.
That was a very good point, because I dare to say that likely some of those individuals who are incarcerated may be some of the best cannabis industry participants. But for most part, thank you, Madam Chair, for the time.
Thank you, Senator Bolkes, for your line of questioning. Senator Potter, Committee Vice Chair, you may proceed with your line of questioning.
Thank you very much, Madam Chair. Good morning, colleagues. Special good morning to, I apologize, good afternoon. It's well into the afternoon. Good afternoon, colleagues. Good afternoon to the people of the Virgin Islands, and a special good afternoon to Ms. Jamila L. Miller Christopher, the governor's nominee to the Cannabis Board. And Ms. Christopher, I just want to first start by thanking you for your willingness to serve in this position. It's always good to see young people willing to engage, willing to get themselves involved in this territory. I wanted to ask you, though, what do you think is the most significant attribute that you bring to the table with regards to sitting on this cannabis board?
I think I would create a balance. I know most of the people on the board are either licensed physicians, or you have people that from the Department of Health, so they're specialists. I think from an HR standpoint, I'll be able to create a balance and be able to, again, like the senator mentioned, providing that balance for equity. And I have that knowledge of policy implementation and understanding rules and regulations.
Okay, fair enough. Lately, I've been seeing more and more articles popping up about the impact, potential health impact of cannabis and recreational cannabis. I was reading an article some time ago, I don't have it, as a Harvard professor who, her position is that we're underestimating the impact that long-term use of cannabis potentially has in communities on young people, potential linkages to mental disease. Yeah. I wanted to know if you've had any thoughts on that. And as a member of the commission, how do we balance, how do we ensure that attention and priority is given towards any potential health risks associated, through the use of cannabis?
So, Senator Prada, I'm not the expert in that field. I'll leave that to the physicians and the scientists, but I believe sitting on the board, I would lean towards them for their expertise to be able to share that information with me. So I will be able, as a board, to be able to make a sound decision on the health impacts and how it will affect our young people in our territory.
Okay. And have you had any thoughts about it? About cannabis, legalizing recreational cannabis, young people smoking potentially more because of it being legal? I mean, any thoughts at all about, whether you think this is something that is potentially could potentially negatively impact this community?
I honestly don't believe so, because our young people are going to find a way to smoke marijuana if they choose to, whether or not it's legal or not. Our job as a board is to ensure that the safety measures are in place, and we educate our community on the health risk to our young people.
1 minute.
Yeah. So I think it's important for us to educate the community.
Okay.
We have to get out there in the forefront and just educate the community and make sure they're educated on,
Awesome.
on the cannabis.
And there's a rule for that. As a member of the Cannabis Board, that is something that you would advocate,
Yes.
us having an educational campaign
Yes.
to ensure. Okay. Excellent. And I was pleased that you seem to be engaged in seeing what's going on in the industry. You were mentioning about state of New York, I believe, and some of the things that they are doing there. Is there anything that you have in mind, any ideas that you have in mind that you may have seen in other states or jurisdictions that you would advocate
Time.
for as a member of the Cannabis Board?
So what I can do is I can speak to from the tourism industry aspect. People today travel for experiential travel, and one of the things, so cannabis, the word is cannatourism. I don't know if you guys read it before. So it's actually called cannatourism, and you will find that people travel for experiential travel, whether or not it's culinary travel or they travel for spa travel. So you'll find that people now are traveling for cannabis experiences. So they'll be looking for it's something called buds and breakfast. So it's kind of like a bed and breakfast, but it's a bed and breakfast where they have the same experience that they have at a bed and breakfast, but their accommodations are cannabis friendly. And sometimes those buds and breakfast offers cannabis products, making it available for them. You have spas that have cannabis in it for facials and massages. Some hotels are making accommodations now for areas where people can smoke, making it cannabis friendly. So those are some of the things that I would advocate for. And that comes from a tourism perspective.
Gotcha. Thank you very much for your willingness to serve. Thank you for your responses. At the appropriate time, I plan to vote in the affirmative for your nomination to this important board. Thank you, Madam Chair.
Thank you, Senator Potter. Madam Clerk, can you please mark Senator Maurice James as present? Senator James, thank you for your attendance. For the listening, viewing audience, my colleagues are slowly trickling in because we are coming from St. Croix Central High School graduation. I just wanted to ask one question, that the applicants who are interested in getting into this business, there's a process. And I ask this because this has been a problem for individuals who have actually called my office inquiring for assistance, for help, for guidance regarding the payment process in place for cannabis applicants. Are you aware of if there's a process already in place where these individuals, when they fill out their applications and they want to pay for their application, if that process is in place? Are you aware, Mrs. Christopher?
I know I perused, I think it was Act 8680. And I know it spoke on the fees, but I am not 100% if that process is in place.
Okay. I'm sure every board, every commission is governed by rules and regulations. Are you aware if this cannabis board has bylaws that is governed by? Are you?
So I know that the rules and regulations are currently, I actually went on the website. So I know they were under review. The copy that I received said under review. So I'm not sure if it's completed or not.
Okay, so Ms. Christopher, if you make it past this committee onto rules and then pass full session through the chair, that we would like a copy of that, if you could share that with this committee.
A copy of
the bylaws, the rules, the regulations that the board is governed by.
Oh, okay, sure.
Okay. Mr. President, you may proceed with 5 minutes.
Thank you. Thank you very much, Madam Chair. Good afternoon to you, my colleagues, and good afternoon to the nominee. I want to take this opportunity before I get into the questions to offer my condolences on the passing of Miss Pamela C. Richards, who was a former executive director of the legislature in the 33rd, as well as she spent time as being a former commissioner of tourism, a press person for former Governor Alexander Farley, and a number of other government jobs that she held. And at the appropriate time, I'm hoping that we could do a moment of silence, just again to memorialize her. I want to thank you, Ms. Jamila Christopher. Oh, also, I want to say congratulations to the CHS class of 2024. Ms. Christopher, I want to thank you for your willingness to serve. And just to ask you, how have you prepared for coming for this job interview? What have you done? Who have you spoken to in respect to come in for this job interview during your nomination process?
So I read, just did a little bit of research. I think the only act that I really read was Act 86. And I think most of anyone that I spoke to was pretty much internal to our department, not anyone outside. I wasn't sure if I can reach out to those because I was a nominee and not an official member of the board.
So tell me how you were selected. Did you offer to be on this board, or were you selected for the board? Did you volunteer, or someone asked you to serve on the board?
So I was asked to serve on the board by my commissioner.
Okay, and as you contemplated serving on the board, can you speak to some of the rationale that was in the back of your head in respect to how do you believe that you could have been a benefit, or some of the challenges that you contemplated before your final decision to serve on this board?
Sure. I mean, I'll start with the challenges. I think one of the challenges for me was the stigma around it and community concerns. The other was my background in being able to implement policy and develop changes throughout our organization. So I felt that I would have been beneficial to do that.
And tell me, were you able, or have you formed any biases or an opinion that may influence you serving on the board?
No, I haven't.
Okay. And can you share with us, some of the research that you have done? Well, before that, have you had an interest in the cannabis industry prior to being asked to serve on the board? Is there anything that you may have read or considered your review in regards to the cannabis industry?
No.
Okay, this is a job interview. Your vague answers could be troubling for me, but so there was no, again, there was no contemplation. You didn't have any research or any reason to have an interest in the cannabis industry prior to this.
No, I mean, I'm going to give you my honest answer, and my answer is no.
Okay, and tell me, as you have been able to now you review the legislation as it pertains to the Cannabis Act. Tell me, and for me, my concern have always been the safety net and rehabilitation. Tell me, from your research thus far, by reviewing the Cannabis Act, is there any area in particular that you see that you would like to have an interest more in than the other areas?
For me, just the concern on the implementation of adult use, ensuring that the laws
1 minute.
protect the children, and that is strictly for adult use only.
Okay. And under questioning, I heard you respond by saying that certainly there is a tourism component to cannabis, and I think you referred to it as the cannabis tourism. There, have you been able to glean from areas such as Colorado and Seattle, Washington, that a lot of the tourism led to individuals that relocated to those states and became homeless and really became a nuisance to those communities more so than a benefit?
No, I haven't read that. I looked more for when I did my research was from revenue estimate aspect and the income, the annual income that
Time.
those states are making from the cannabis industry.
Excellent. Madam Chair, if I may just
You may
wrap up with this
proceed.
final question. And obviously, that is one of the areas that we want to focus in as well in this community, because the implementation of cannabis was really about revenue generation. So tell me, how do you see the implementation of the Cannabis Act to really increase our revenues? What do you believe as a community we need to do? As a government and perhaps even the board, what do we need to do to ensure that we are realizing the type of revenues that we think that we could realize from implementation of the Cannabis Act?
So some of the industries that's already already performing or working in the cannabis industry. So their annual revenues are about $1 billion. But I think one of the things that we need to do is ensure that our community, one, is educated, ensure that that we have controls and policies in place. And then once those policies and controls are in place, then we look to the Department of Tourism for them to market and promote the cannabis industry.
I want to thank you very much for your responses, Ms. Christopher. I'm not a member of this committee, but I try to attend as many of these hearings because eventually I do have to vote on the nominees. So thank you for your response. Thank you very much, Madam Chair, for the time and the leniency.
Thank
You're
you,
welcome.
Senator Francis, for your line of questioning. Ms. Christopher, what would you say would be your most valuable contribution you hope to offer to this board?
I would say my knowledge.
Your knowledge on what? The senators mentioned it earlier. This just act like this is a job interview. We know you have another paying job, but the governor nominated you to be on this board, and this is just part of the process to ask to see if individuals who serve on this committee feel that, yes, this is a good candidate for this board. So I ask, what is your most valuable contribution you hope to offer to this board? Tell us. Let us know how we think that you are the best fit for this job.
So I believe my knowledge into the tourism industry, my knowledge into applying rules and regulations, whether or not it's in an organization or to any rules or bylaws that may exist.
Senator Maurice James, you may proceed with 5 minutes. Yes, Senator, you are the 4th senator for line of questioning.
Good afternoon, Virgin Islands. Good afternoon. Thank you, Madam Chair. Good afternoon, Virgin Islands. Good afternoon, testifiers, colleagues, staff. I too want to express my condolences to the family of Pam Richards. I know her really well, and over the years, we've had interactions that were very meaningful, and so we all know that she contributed to the Virgin Islands in various capacities. So my heart goes out to the family, and may her memory be a blessing. I also want to congratulate, I was at the St. Croix Central High School graduation, and I want to congratulate all the graduates, their families, the teachers, and all those in attendance. This may sound a little strange, but I need to tell my colleagues, thank you for your service in a big way. As everybody knows, I'm a first-term senator, but you really move from one place to the next, and you get cussed out if you don't show up. You get cussed out if you show up. Lord Harry. So anyway, so thank you for your service. Let me just say that. If no one else tells you that, I'll tell you that right now. Miss Christopher, I am so ignorant of the cannabis industry that I am going to just have a conversation with you about comparing us as an island to other islands. Will this distinguish us in any way from the other islands in terms of cruise ship visits or air travel? How would we be able to, or how do you envision, especially since you're coming from the Department of Tourism? You may have talked about this before, so I apologize because I came in a little late. But how would you convince, or what would you convince the other board members that we should do to distinguish ourselves as a tourism cannabis destination? I heard you say something about something with bed and breakfast, with buds and breakfast, something like that. Explain, I mean, let's just talk about that, because I am very ignorant of the cannabis industry, except what I've seen on the TV. In terms of the industry now, that's what I'm talking about, right? Can you talk to me a little bit about that?
Sure. So I think I think we have one thing that stands out against all the other islands is that, one, we don't need a passport to travel to the U.S. Virgin Islands. And I think in terms of tourism, and this is just my opinion, in terms of tourism is making the territory, if that's the avenue that we decide to go in, cannabis friendly. So as far as, like I mentioned before, accommodations, you may have restaurants that may be doing culinary for cannabis, so they may offer foods that has cannabis that's infused. Some of our local spas may be able to offer those services. So just from that aspect, making the territory friendly. So when people look to come and visit and do research on the island, one of the things that they may look for is, are we cannabis friendly? And we can provide we'll be able to provide some of those services for people that may want to travel for cannabis leisure.
Do you, thank you for that answer. Do you think that, and again, I'm going to admit my ignorance with respect to what the statute and the acts that we've passed in connection with cannabis. Well, one concern of mine is that fair and equal opportunity for anyone who wants to get into this business, in this industry. Have you thought about protections or...
Time.
Madam Chair, may I wrap up?
You may conclude.
Any I don't want to say preferences necessarily because we are in a U.S. jurisdiction, but how do we ensure that everyone gets a fair and equal opportunity, I'll use that word, to engage in this industry?
So I think guidelines have to be built around the policies on what people need to apply, what are the basic guidelines for an application, whether or not it's the fee, whether or not your background, if background checks are going to be included. Those are all implemented through the policies that will come from the board.
Thank you, Madam Chair.
You're welcome, Senator James. Ms. Christopher, if we can get your full attention, please. Seems like you have a distraction, and we would like your full attention. How would you build a relationship between the board and the community? because they're decisions that will impact the community. How would you strengthen that relationship with the board and the community?
So that comes with having community forums, educating the community, keeping the community engaged, doing each step of the process on what the board is doing, having press releases on any changes or upcoming changes, having the community be able to come in and ask questions, or their concerns can be addressed as well.
Would you have like town meetings, that kind of stuff for the community? Because this would be a new, venture for the Virgin Islands. So would that be an idea that the board would probably think about having town meetings? Well,
I think town meetings are actually an excellent idea.
okay, I'd like to acknowledge at this time committee member, Senator Franklin Johnson. Senator Johnson, thank you for attending, who was also at the St. Croix Central High School graduation. Senator Johnson, you just happen to be the next senator to ask your line of questioning to Mrs. Christopher, who's before us. Thank you.
Good afternoon. Thank you very much, Madam Chair. Good afternoon to my colleagues. Good afternoon to the listening and viewing audience. And I definitely want to say Go Caribs. Was a beautiful graduation there today. Had a wonderful time. Those children really are poised and ready to get out into this community and make their mark. Ms. Christopher, good afternoon. How are you doing?
I'm doing great. Good afternoon.
I been to like the graduation, as they say, but I want to ask you a few questions, and if the questions have been answered before, then we could just, I guess, say a little bit more to me. What are your plans to ensure that cannabis tourism is marketed responsibility, both with local and international visitors? And have you been looking up the industry and how it's going to be revolving and being very active in our community?
Can you repeat the question?
I think I just reached, but I saw what my colleagues were speaking about. I would like your attention, not your phone. I would appreciate that very much. And I'll ask my question again. What are your plans to ensure that the cannabis tourism is marketed responsibility, both to the local, international visitors? Can you hear me?
Yeah, I can hear you. And your question, I'm sorry, can you repeat it?
All right. Thank you very much, Madam Chair. I have no further questions.
Thank you, Senator Johnson. I'd like to acknowledge committee member Senator Kenneth Gittins. Madam Clerk, can you please mark Senator Gittins as present? At this time, the Committee of Rules and Judiciary will take a quick recess. The Committee on Rules and Judiciary is out of recess. Do I hear a motion on the governor's nomination of Jamila Christopher? Do I hear a motion? St. Thomas, Senator Potter, you're recognized for your motion. Can you please recognize Senator Potter's mic?
Thank you very much. Thank you very much. Madam Chair, I move that the governor's nomination of Jamila L. Christopher as a representative of the Department of Tourism to the Virgin Islands Cannabis Advisory Board be favorably voted upon in the Committee of Rules and Judiciary and forwarded to the full body for further consideration and action. I so move.
Second.
Properly moved by Senator Potter, seconded by Senator Bolkes. May I have a roll call on the motion?
Senator Angel L. Bolkes Jr.
Yay.
Senator Bolkes Jr., yay. Senator Diane T. Capehart.
Nay.
Senator Capehart, nay. Senator Kenneth L. Gittins. Senator Gittins, absent. Senator Maurice C. James. Senator James, nay. Senator Franklin D. Johnson. Senator Johnson, nay. Senator Carla J. Joseph. Senator Joseph, absent. Senator Milton E. Potter.
Yes.
Senator Potter, yay. Madam Chair, you have 2 yeas, 3 nays, and 2 absent.
Thank you, Madam Clerk. The governor's nomination, the motion fails. The governor's nomination of Jamila L. Christopher, representative of the Department of Tourism, Virgin Islands Cannabis Advisory Board, did not receive a favorable vote in the Committee of Rules and Judiciary and has been forwarded to the full body for further consideration. Ms. Christopher, this is the time that I let nominees give a few words. Unfortunately, you did not receive a favorable vote from this committee. I would allow you to have a few words. You have about 30 seconds. You may proceed.
Just like to thank the committee for allowing me to come before. Thank you for the break. This is my first time before a Senate body for a nomination, so my nerves were a little bit rattled. But just thanks.
Thank you. At this time, the committee will stand in recess before we have our testifiers for Block 2. Colleagues, the committee stands in recess 5 minutes. The Committee on Rules and Judiciary is out of recess. Colleagues, we are now in Block 2 on the agenda. But before we go into Block 2, I just wanted to say a few words. Each person that comes to the Rules and Judiciary Committee, when the governor submits their name for nomination, boards, commission, commissioner, this is like a job interview. And I think we always take the time to tell individuals, thank you for your willingness to serve these boards or commissions that have a need to make a quorum to vote on impactful things for their boards. So I just want to say that if you're not interested in serving, let the governor know. Don't demonstrate in a committee of rules meeting that you may not be interested, that you don't have the zeal. So I just wanted to say this. So individuals who are nominated, if you are nominated to serve on a board or commission, I do have a conversation before you coming to this meeting. Have that one-on-one conversation. So just giving you an idea of what you are going to experience when you're on the floor. You're going to be asked questions that I may not know what my colleagues are asking, but we ask that the respect that we give, we want it to. Colleagues, Block 2 is Bill number 35-0121. Who speaks on this bill? You may proceed, Senator Francis.
Thank you very much, Madam Chair. Madam Chair and colleagues, I speak to Bill number 35-0121, an act amending the Versailles Code, Title 4, Chapter 29, Section 382, and Title 5, Subtitle 1, Part 5, Chapter 6, Section 660, increasing jury and witness fees and allowances, respectively. Bill number 35-0121 seeks to reduce the financial hardship for those persons serving as jurors and witnesses in our judicial system. I remember many years ago when the late District Court Judge Raymond Finch sent out his marshals to round up people who had not reported for jury duty. It was that important for him that everyone have the same access to a jury of their peers. While jury service is described as the cornerstone of civic engagement, the costs associated with serving on a jury make it economically challenging for many throughout our community, thereby restricting access to a jury of your peers. This bill is an attempt to close the gap between how much jurors are compensated and the amount they will lose if they do not receive their usual income during jury duty, jury service. Bill number 35-0121 would also increase the amount paid to witnesses. We rely on witness testimony to close cases and bring perpetrators to justice, yet pay a fee that has not kept pace with the cost of living in this territory. Essentially, Bill number 35-0121 is intended to support the ability of people to fulfill their civic duties. And again, in my law enforcement career, we have seen where a lot of times a case could quickly go south after a tremendous amount of work have gone into this case. Individuals have been injured, and victims, and they go free as a result of witnesses not coming forward. So we understand the importance of this. Civics have a lot to play with this, and I've been on the rant regarding civics for a number of years. Back in 2016, I moved Act 7934. It was really talking about how civics and the individual's responsibility to civics. I'm asking for my colleagues' support on this measure. We have some testifiers that will be speaking at this at the appropriate time. I'm sure based on some of the recommendations that have been made or will be made by our testifiers, we will be seeking to make some amendment as we move forward on this measure. I ask for the committee members to fully support this as we move forward. Thank you very much, Madam Chair, for the time and opportunity and presentation of Bill number 35-0121.
Thank you, Senator Francis. I too am a sponsor of that, prime sponsor of that bill. So thank you, Senator Francis. Madam Clerk, are there any correspondence to be read into record?
Yes.
Please proceed.
35th Legislature, Committee on Rules and Judiciary. Testimony on Bill number 35-0121. My name is Julie S. Tadman, and I am the Chief Territorial Public Defender. I thank the members and staff of the Committee on Rules and Judiciary of the 35th Legislature for this invitation to testify on proposed Bill number 35-0121, an act amending Virgin Islands Code, Title 4, Chapter 29, Section 482, and Title 5, Subtitle 1, Part 5, Chapter 61, Section 660, increasing jury and witness fees and allowances respectively. I thank Senators Francis and Capehart, especially as co-sponsors of the proposed bill, which will enhance the jury system of the territory. The Office of the Public Defender is established by Title V, Section 3521 of the Virgin Islands Code to represent the indigent charged with crimes in court. Our Constitution and the revised Organic Act provide for trials by jury of one's peers. Juries are the bedrock of our judicial system. It is the jury that determines the facts of the case, the critical issues of life and liberty for litigants. For an equal playing field, our clients depend on a sound jury. Therefore, the Office of the Territorial Public Defender welcomes any effort to enlarge the pool of jurors and enhance the effectiveness of the jury system. By failing to provide jurors with reasonable pay for the service, we fall short of the Constitution's promise. This bill seeks to correct this. It has our full support. As the U.S. Supreme Court has stated, the purpose of a jury is to guard against the exercise of arbitrary power, to make available the common sense judgment of the community as a hedge against the overzealous or mistaken prosecutor, and in preference to the professional or perhaps over-conditioned or biased response of a judge. This prophylactic vehicle is not provided if the jury pool is made up of only special segments of the populace or if large distinctive groups are excluded from the pool. Jury participation research shows that adverse financial consequences explain high no-show rates for those called to jury duty. We also know from psychological research that deliberative bodies with broader representation have longer and more substantive discussions based upon their different perspectives. In a phrase, low juror pay results in our clients having less representative and less effective jurors. Indigent members of society are often least able to contribute their time because of economic constraints. Every attorney has heard jurors describe their hardships to the court as they seek an excuse absence from serving on a jury panel. Childcare and employment responsibilities come up in every jury panel. Increasing juror pay helps to alleviate these concerns, especially to those in our society to whom these dollars mean the most. The American Bar Association identified juror compensation as one of its key principles for juries and jury trials, noting that it is critical that persons called for service be paid a fee that at a minimum defrays routine expenses such as travel, parking, meals, and childcare. According to a 2022 report on juror compensation from the National Center for State Courts, this action by the 35th Legislature would move the Virgin Islands from one of the lowest ranking jurisdictions for juror compensation to one of the higher ranking jurisdictions. Based upon the comparative cost of living and a level of poverty in our territory, this legislative change has a greater chance of making a difference in our islands than in most jurisdictions. Section 2 of this bill proposes to increase witness fees and subsistence allowances. This will result in greater participation by indignant litigants in judicial and administrative proceedings, including our clients. On behalf of the Office of the Territorial Public Defender, I would like to express our full support for the bill. It is both timely and needed. Madam Chair, that's the end of the correspondence.
Thank you, Madam Clerk. I'd like to acknowledge non-committee member VP Blyden. Thank you for attending the Rules and Judiciary meeting. You're number 7 on the rule, just letting you know. Colleagues, at this time, I'll have the testifiers that sitting in St. Thomas, starting from left to right on St. Thomas. If you can please identify yourself, stating your name, from left going right. You may proceed.
Good afternoon, Deputy Attorney General Ian Clement, Department of Justice.
Thank you.
Good afternoon, Regina DeChabert Peterson, Administrator of Courts, Judicial Branch.
Thank you.
Good afternoon.
You may proceed.
Good afternoon. Attorney Jessica McKinney, Chair of the Legislation and Law Reform Committee from the Virgin Islands Bar Association.
Thank you. At this time, we would start with Mr. Clement. Do you have a testimony to read? You may proceed.
Good afternoon, Madam Chair, CAPART, Committee on Rules and Judiciary members, legislative staff, and those of you in the viewing and listening audience. My name is Ian S.A. Clement. I am the Deputy Attorney General of St. Thomas, St. John, and Water Island District of the Department of Justice. On behalf of Attorney General nominee Gordon Ray, I am pleased to provide a few remarks regarding proposed bill number 35-0121. Bill number 35-0121, as proposed by Senator Diane T. Capehart and Novell E. Francis, is a comprehensive piece of legislation. It seeks to amend Title IV of the Virgin Islands Code, Chapter 29, Section 42, and Title V of the Virgin Islands Code, Chapter 61, Section 660, to increase jury and witness fees and allowances. The Department of Justice has thoroughly reviewed this bill and is ready to provide detailed comments. Currently, under 4 Virgin Islands Code Section 482, jurors in the Virgin Islands are entitled to compensation as provided for in Sections 1864 and 1871 of Title 28 of the United States Code. The federal statute provides jurors an attendance fee of $50 per day. While there is no legal requirement to pay jurors for their service, every state compensates residents serving on civil and criminal juries. This compensation varies from $5 to $50 per day, with some states also providing mileage reimbursements to help cover the cost of traveling for jury duty. If Bill number 35-0121 is approved, the existing language in 4 Virgin Islands Code Section 482 would be replaced. The new provision would allow jurors impaneled for trial to receive $80 or $40 per half day of service. Jurors who participated in the jury selection process but were not selected to sit on the jury would be entitled to $20 per day or $10 per half day for their service. Bill number 35-0121 also provides reasonable compensation for travel, parking, and a subsistence allowance covering meals and lodging as determined by the court. It is important to note that jurors employed by the local or federal government will not be eligible for these payments. Additionally, 5 Virgin Islands Code Section 660 currently allows witnesses to be compensated at a rate of $4 per day plus an additional $8 per day for subsistence. As stated in Bill number 35-121, neither 5 Virgin Islands Code Section 660 nor the compensation rate for witnesses has been updated since 1957. If amended, 5 Virgin Islands Code Section 660 would allow a witness attending court or appearing before an administrative judge to receive $80 for each day's attendance and an additional allowance of $100 per day for subsistence, including the time necessary occupied in going to and returning from the place of attendance and for incidental inter-island travel costs. As you evaluate and vote on Bill number 35-0121, the following should be considered. First, while the language in the newly created 4 Virgin Islands Code Section 482A would increase the amount jurors are compensated for their service, it does not identify the party responsible for making these payments or a funding source for the increased fees. Bill number 35-0121 should clearly state who will make these increased payments and how they will be funded. Second, the language in proposed 4 Virgin Islands Code Section 482B allows for reasonable compensation for travel, parking, and a subsistence allowance covering meals and lodging as determined by the court, but once again does not provide a funding source for these expenses. While one can assume the courts will be responsible for paying these fees, Bill number 35-0121 does not make this clear. Again, this bill should clearly state who will make these increased payments and how they will be funded. Third, the language in 4 Virgin Islands Code Section 482C and 5 Virgin Islands Code Section 660 makes federal and government of the Virgin Islands employees ineligible from receiving benefits as a juror or witness. Since the territory does not regulate federal employees, the reference to federal employees should be reconsidered. The Department of Justice is unclear about the legal basis for denying payments to federal employees. Additionally, 3 Virgin Islands Code Section 586 provides leave for jury service for GVI employees without loss of pay or deduction from annual leave for the time required for jury service in the Superior Court or the Superior Court or District Court of the Virgin Islands. Fourth, while the second sentence of Virgin Islands Code Section 660 includes salaried GVI and federal employees, the first sentence does not. As presented, any witness attending court in the Virgin Islands should be eligible for witness pay regardless of their status as a government employee. But the practice is a government of the Virgin Islands employee who testifies for the government as a lay witness is only entitled to their normal salary. For consistency, I would consider preventing government of the Virgin Islands employees, whether salaried or not, from receiving witness compensation when testifying on behalf of the government and within the scope of their employment. Additionally, this section does not contemplate when a government employee acts as an expert witness or when a retiree is called as a witness. Finally, the second sentence of 5 Virgin Islands Code Section 660 provides an additional allowance of $100 per day for subsistence, including the time necessary occupied in going to and returning from the place of attendance and for the incidental inter-island travel costs. Does the legislature intend for this $100 to be in addition to the reimbursement for necessary and reasonable expenses of travel to and from a witness's place of residence, already outlined in the first sentence? As proposed, some witnesses may be eligible to receive a daily fee of $180 or more. The decision to increase juror and witness fees and allowances is a policy decision and not a legal one. However, the Department of Justice supports Bill number 35-0121 in principle. By increasing the compensation rates for jurors, this legislature can help close the financial hardship jury duty creates for some citizens. The Department of Justice is also hopeful that increasing the fees paid to jurors will increase and diversify the jury pool. With that, I will want to thank the committee for allowing the Department of Justice to testify on Bill number 35-0121. This concludes my formal remarks. I stand ready to respond to any questions this body may have.
Thank you, Attorney Ian Clement, Acting Attorney General from the Office of Attorney General. At this time, we will hear the testimony from Ms. Regina Peterson, Administrator of Courts, Judiciary of the Virgin Islands. You may proceed with your testimony.
Thank you. Good day, Chairman Capehart, members of the Committee on Rules and the Judiciary, and other members of the 35th Legislature present, staff, and listening public. I am Regina DeShabir Peterson, Administrator of Courts for the Judiciary of the Virgin Islands. I would like to take this opportunity to thank, I'm sorry, I'm scrolling. I would like to take this opportunity to thank the committee and the bill sponsors, Senator Novelli Francis and Senator Diane Capehart, for this opportunity to appear before you and provide brief testimony concerning Bill number 350121. As this committee is aware, all states and territories provide compensation to citizens called to serve on civil and criminal juries, typically on a fixed flat rate or a graduated per diem rate. While there is no uniformity nationally in the amount of juror compensation, what is common across all jurisdictions, I'm sorry, this is scrolling too fast. What is common across all jurisdictions is that a juror's daily compensation is far below the minimum wage and certainly below the living wage that any individual could expect to earn in the course of their regular employment. That fee would be considerably less for a juror that is self-employed. To be frank, inadequate compensation for juror service is a real concern for the effective and timely administration of justice. As this committee is aware, the local judiciary pays $40 for a full day of service, $20 for a half day of service, and $5 per day to defray the cost of transportation. These fees were set in 1976 by statute as part of the same legislation that created the Territorial Court of the Virgin Islands and have not been modified since, despite substantial increases in inflation and the cost of living in the intervening decades. Accordingly, the judiciary fully supports the legislative effort to increase fees paid to jurors. With regard to the current bill before you for consideration, we make the following observations and recommendations for technical amendments to resolve ambiguities and otherwise improve the legislation. Bill number 350121 would repeal and replace Section 482 of Title IV of the Virgin Islands Code, but not change Section 81 of Title IV of the Virgin Islands Code. Importantly, Section 81 in subsection B provides that jurors shall be paid for each day of active service a fee equal to that paid to jurors in the district court pursuant to Section 482 of this title. Bill number 35-0121 should be revised to repeal Section 81B. Section 1 of Bill number 350121 adds a new subsection A that fixes the fee of jurors at $80 per day for a full day of service, including if selected to serve on a trial, but only $40 for half a day. Additionally, jurors who appear for jury selection but are not impaneled receive only $20 for a full day and $10 for a half day. These amounts, while an improvement over the fees currently in place, may also become insufficient due to inflation and changes to the cost of living. We recommend that Section 482A be amended to start with and I quote, unless a higher rate is set by the judicial branch, which would set the fees in the bill as a floor and provide the judicial branch authority to raise some or all of the rates at timely intervals based on inflation or other considerations without the need for further legislation. Third, Section 1 of Bill number 350121 would, among other changes, add a new subsection B to Section 482 that provides in its present form, jurors shall be provided, if necessary, reasonable compensation for travel, parking, and subsistence allowance, and a subsistence allowance covering meals and lodging as determined by the court. The use of the word court creates ambiguity because it is not clear what the word refers to. Act number 7888 vested the judicial branch administrative office with responsibility over court finances, subject to the retained authority of the Supreme Court. Section 514 of Title IV also provides that in all cases where fees are not specifically covered by this chapter, the Supreme Court shall fix the amount thereof by order or rule. Therefore, if this language is intended to provide the court with the authority to provide compensation to all jurors for parking, meals, and the like, the phrase "the court" should be replaced with either the administrator of courts or the Supreme Court. Fourth, Section 1 of Bill number 35-0121 would, among other changes, add a new subsection C to Section 482, which provides that jurors employed by the federal or government of the Virgin Islands and who receive regular compensation and benefits while serving on a jury shall not be paid the fee described in subsection A. While the legislature possesses the authority to mandate that employees of the government of the Virgin Islands not receive a fee for jury service and instead receive their regular compensation, the legislature cannot force the federal government to do the same and vice versa. The federal district court, for instance, pays juror fees to employees of the Virgin Islands government while withholding such fees from federal employees. Fifth, part of this is a record-keeping issue. The judicial branch has no process to validate whether the federal government is or is not paying its employees while serving on a superior court jury. We recommend that the reference to federal government be deleted and leave the federal government to determine whether or not their employees should be permitted to accept juror service fees. With regard to withholding juror payment based on employment status with the local government, the judiciary will have to explore whether functionality exists in our jury management system or whether further configuration or licensing may be required. The judicial branch's current personnel policy is that employees who are summoned for jury duty are granted administrative leave for service, but any fee received other than that for travel and transportation must be tendered to the judicial branch. We make no recommendation in this regard and would make the necessary policy adjustments based on the law as it is enacted. Finally, with respect to Section 2 of Bill number 350121, it is important to note that fees paid to witnesses do not involve the judicial branch. Witnesses are, of course, crucial to the administration of justice, and without them, very little could happen. But normally, the courts do not pay the fees of witnesses called to testify in court or to appear for a deposition. In closing, with the increase in jury trials following the global pandemic, we are quickly approaching normal expenditure levels for jury service. In this regard, with the proposed increase, we are projecting that those costs could increase by 100% in FY 2025. This projection will be included in the Judiciary's fiscal year 2025 budget submission. Thank you for allowing me to provide testimony on this matter of great public importance.
Thank you, Mrs. Regina DeChavere Peterson, Administrator of the Courts. Thank you for your testimony. At this time, we'll have Attorney Jessica McKinney, Chairperson of the VI Bar and Law Reform Committee. You may proceed with your testimony.
Good afternoon, honorable members of the 35th Legislature. I am here today in my capacity as chair of the Virgin Islands Bar Association Legislation and Law Reform Committee. The committee's goals are to review bills for efficiency and effectiveness, encourage stakeholder engagement, and provide input on potential human rights and public interest impacts. To note, these comments have not been reviewed or approved by the Virgin Islands Bar Association Board of Governors and do not necessarily reflect the views of the bar. Regarding Bill 350121, I would like to make technical and practical comments to aid in consideration and drafting of this bill as laid out below. Consistency. The first whereas clause of the bill states that the Virgin Islands should pay at least the Virgin Islands minimum wage, currently $10.50 an hour for jurors. However, in order to maintain consistency with this statement, it seems the currently proposed amounts would need to be raised slightly from $80 for a full day and $40 for a half day to $84 for a full day and $42 for a half day. This may also help maintain consistency with any increases that occur in the future. For example, if they are raised based on an increase in the minimum wage. Terms. Section 482B states that jurors shall be provided, if necessary, reasonable compensation for travel, parking, and a subsistence allowance covering meals and lodging as determined by the court. However, the term if necessary may create an unintended high standard for jurors to access reasonable compensation. This may possibly occur because the court needs to read meaning into any words included in a law. Therefore, it may be helpful to consider replacing if necessary with another term, such as if applicable or if appropriate, to allow the court more discretion to decide when the reasonable compensation is appropriate. Monetary amounts listed in statutes. Monetary amounts listed in statutes may be difficult to update to align with changes in inflation, minimum wage, cost of living, etc. This is particularly because laws may remain in place as is long after they are passed. This makes it helpful if the laws are flexible enough to account for changing circumstances. Therefore, the legislature may want to consider adding language that allows for changes to the monetary amounts currently listed in the bill. For example, to increase the pay amounts automatically based on inflation, to increase the pay amounts automatically if the minimum wage in the U.S. Virgin Islands or federally is increased above $10.50, and or to give the courts the authority to raise the pay amounts. I'm happy to speak more about my comments or this bill, and I appreciate your consideration.
Thank you, Attorney McKinney. Colleagues, that concludes the reading of the testimonies from our testifiers that we have before us today. In the essence of time, I think we'll proceed with the line of questioning, beginning with Senator Bolquez. You may proceed with 4 minutes.
Thank you, Madam Chair. Good afternoon, colleagues. Good afternoon to the testifying panel here today. And I wanted to start off by asking Ms. Peterson of the Judiciary, how, in essence, if this measure moves forward, do you see any implications concerning how you can manage financially with the new rates? Would you need to request more funding, or is it something that you can absorb?
Good afternoon, Senator Regina Peterson. We have run some numbers and done our forecasts, and that's why we are anticipating 100% potential expenditure increase for our jury expenses, and we will be adjusting the numbers in our budget accordingly.
Could you share with us about, based on your calculations, about how much would that be?
I think right now our ask is probably going to be slightly south of $500,000 for juror expenses at that 100% mark. We've been looking with the increase in jury trials, we've been tracking closer to $200,000 now in our normal expenditures for juror expenses. And so that's why we're going to just double that projection.
Okay, noted. And of course, as mentioned, in speaking here today, we heard that our numbers are technically the lowest in the country. I mean, I do believe that it is about time to make things whole in the sense of dealing with the cost of living, inflation, etc. We still have a lot of work to do here in our territory. So I want to move forward to Mr. Clement of the Office of the Attorney General. And you mentioned that the current juror compensation, as I was saying, is provided under sections of 1864 and 1871 of Title 28 of the USC.
Yes.
And how does this federal framework compare to the proposed changes in this bill 35-0121? What exactly would differ in the sense of that? Would we be aligned with that federal code? Or is it just the fact that we're just raising the compensation level?
Ian Clement, Deputy Attorney General, I believe that we would be raising the compensation from what's pegged in the federal statute.
Okay, and what does the federal statute state for compensation currently?
I would have to pull that.
You may have to pull that.
Yeah.
Okay, so while you pull that, I'm going to move on to the VI Bar Association, Ms. McKinney. Good afternoon. You mentioned the difficulty of updating monetary amounts listed in the statutes to align with the changes of inflation and the cost of living. And you also mentioned changing and replacing terms of applicable, if applicable and if appropriate in Section 482B. Out of those two, which one do you think would best suit the bill and why? And of course, concerning my previous part of the first section of the question, I hope I'm not confusing you. What mechanisms do you believe we need to establish to update this code regularly? Because if we're updating the cost now, we may need to update it 10, 20 years from now, right?
Attorney Jessica McKinney, Chair of the Legislation and Law Reform Committee. And just to be clear, what I'm saying is only for the committee. It's not on behalf of the Virgin Islands Bar Association in a wider sense. And thank you for your questions. For me, I would say for the terms one, if you were going to change it from if necessary to if applicable or if appropriate.
You may conclude.
It may depend on the goals. It may depend on the goals and the needs of the court. If applicable, if appropriate, would give the court more, they would have more discernment on whether to give it or not. If applicable, then it may give more rights to the community to make sure that they are going to receive compensation whenever they are having these expenses. I don't know if...
the other part was just if you believe that there should be provisions to establish if this needs to be regularly updated every 10, 20 years or whatever.
So I'm not sure if stating that it needs to be updated regularly would be helpful, because whenever you put a requirement, you're further butting up against current capacity and things that are needed. So, adding language that is flexible and going to allow for changes outside of going through the full process of legal amendments or changing the bills allows for the government agencies, divisions, departments, bureaus, et cetera, to update internally as time changes. And so that they're not stuck with what's been input into the bill. And so adding the language is going to allow them that flexibility, because honestly, it may need to be updated a lot sooner than 10 or 20 years. And so they're able to make those decisions, as things are changing, as their needs are changing, and the community, et cetera.
Okay, I appreciate the response. And Madam Chair, if you can please give the Acting Attorney General an opportunity to answer the previous question. I appreciate it. Thank you for the time.
You're welcome. Attorney Clement, you may proceed.
Thank you. Deputy Attorney General Ian Clement, Department of Justice. The fee under 28 USC 1871 is $50 per day, but also there are some varying amounts based upon the length of the time that the juror sits on the jury. So if it's more than 10 days, it's a certain amount. If it's if it's a longer trial, it's a certain amount. But basically, the average amount or the base amount is $50 per day. So for a full day, this would increase the jurors' compensation from that pegged amount to $80 for a full day. It'd be a little less for a half day, being $40.
Thank you.
Point of information, please.
Points of information, Senator Blyden.
Thank you, Madam Chair. Administrator of the courts, Regina Peterson, you spoke to the last speaker in respect to the budget amount that's needed, upward of $200,000. You said close to $500,000 in the 25 budget. Does that amount include witnesses? Because we're speaking about compensation, but witnesses is part of that. So does that include that amount also?
Respectfully, Senator Regina Peterson, the court generally is not responsible for witness payments.
Okay, very
That's
well.
not coming out of our budget.
Very well. Thank you for that clarification. Thank you so much, Madam Chair.
Thank you. I just want to say this. From 1954, 1957, there are a lot of VI codes that need to be revised. And this is why I'm having conversations, the Senate President and I, the legal counsel, having conversations with the government to say, hey, departments, this is the time to look at your department, look at legislation that is impacting your department, that's been there since the beginning of time and needs to be revised. So we're having discussions to have a symposium so departments, high priority areas would come to us and say, we need these amendments. So this is the purpose of this bill, because I have individuals, when I speak to, especially the young people, they said, I ain't voting, I ain't registering, because when I register to vote, then I get called for jury duty. And you ever see the amount of money that it'll give you? I ain't going to register to vote so they could call me. This is something that's important for the territory, to increase this pool of individuals to be part of the process.
Reasonable, ma'am.
So, Senator Potter, you're number 2 on the list, so you may proceed with 4 minutes.
Thank you very much. Thank you.
You're not on.
Thank you.
Can you please acknowledge?
Thank you very much. The microphone is operational now, Madam Chair. Thank you very much. Good afternoon to testifiers here before us today. I want to first just extend kudos to the bill sponsors for having the foresight to propose these necessary fee adjustments when it comes to jury and witness fees. Based on the testifiers, the last time this was addressed was in 1976. That is very, very surprising. Very, very surprising. So an adjustment is definitely needed. Administrator Peterson, District Peterson, you mentioned that the witness fees really are not the responsibilities of the judiciary which entity is responsible, to your knowledge, for paying witness fees?
Generally speaking, it would be whoever the subpoenaing party is. It could be defense counsel, it could be the government, it could be VIPD, but it doesn't come out of the court's coffers.
Okay, okay. Thank you for that. As far as your regular jury expenses historically, has that number been rising, staying the same, decreasing?
Our expenditures are increasing, and we've looked at the past 5 years. Of course, we've got the anomalies of the pandemic and the storm. So we're now building back to where we used to be normally. But driving some of that increase, of course, is just the increase of doing business, not just the fees for the jurors, but when the jurors are impaneled and on service, we feed them, we do a lot of other things, and the cost of those items are also increasing. So we're not quite at our I would say 2017 levels, but we're quickly approaching those numbers again to then be able to readily forecast what our real expenses will be in the future.
Okay. You know, this whole jury experience is never something that people find pleasurable, find enjoyable. So for sure, increasing the fees, you know, the amount that a juror receives, I can see it being a positive, you know, an overall positive. I have been to post offices where persons get the jury summons and they toss it. They just toss it. I'm just curious as to that process. I thought that process involved like a sort of bail process. Maybe it's a district court, because I know I've solved that.
And that would be, if you add certified mail, you can imagine what our expenses would look like, because certified mail is not cheap either. But yes, we do go through that process. We issue sometimes upwards of 8,000 questionnaires, you know, every cycle. And out of that, we may qualify, you know, 700, you know, less than 10% people are qualified for service, and then fewer are actually impaneled. Okay. So yes, a lot of them are returned. Mm-hmm. We do return receipt, but a lot of them are returned undelivered or unclaimed is actually.
And there's really no way of tracking these folks down. But from a cost benefit analysis, as the court administrator, you're saying that it's probably better, you're probably better off just keeping it the way it is, as opposed to imposing a certified mail return receipt process to hold people accountable.
We get them back. So we do return receipts. So we do get them back. We send them out and we get them back. So we do get them.
Okay.
But that's just the process. That's for us. That's the cost of doing business. Right now, we use, of course, Board of Elections and driver's licensing as our, you know, listing references for sending out those questionnaires. And you know, we're exploring other options to see if we could reach a broader audience. But those are the tools that we are utilizing.
Got you. Thank you very much, Madam Chair. I want to abuse my time. Thank you for your responses.
Thank you, Senator Potter, for your line of questioning. We'll proceed with Senator Maurice James. You may proceed with 4 minutes.
Thank you, Madam Chair. First of all, I want to commend the sponsors, Senator Francis and Senator Capehart. I believe that this bill is necessary. I mean, when you think about how long ago the bill has been enacted, how many years have gone by, we really need to update this particular one, and it will really result in a better cross-section of jurors. I also want to say to the testifiers that I appreciate your comments regarding changes that should be made. And so when it comes to those comments especially from the court and also from the Bar Association. I believe that we should review those and take serious consideration of the recommendations they have made. I do want to ask whether or not right now, if there is a difference between jurors who are in the jury selection process and those that are in panel for trial. Right now, do we pay them different amounts, or is it a standard amount whether you go on to serve during the trial? Or is it one standard amount, one standard fee?
Good afternoon, Regina Peterson. In terms of the actual payment process, like you get paid based on your day of service. So without any distinction to impaneled or not impaneled. So it would be $80 a day and $40 a half day, but there is no distinction between the two.
Okay, well, this bill does do that. It says for impaneled 80, and for those who participated but were not chosen to serve on a jury, they would receive 20 per day. And I'm not sure why this is so, and I'm just wondering if you agree with that, because it would seem to me time is time, right? And
yeah,
how long does let me hear your opinion, because that was what jumped out at me. Section 482 jury fees A. That's what I'm referring to.
And actually, I think that's why we made the suggestion about having the fees set almost as a floor and not a ceiling, and allowing us the flexibility to make those adjustments. Because while I didn't put it in this version of the testimony, one of the analysis did show that based on the current wording of the bill, the $20 for those not serving would actually be $10 less than they would have been paid under the current system. So we figured instead of getting technical with all those changes, that we would just suggest that you give us the flexibility to work those nuances out.
Yeah, I definitely agree with that, but I actually don't even like the fact that it has the $20 per day, and it's $10. So I'm going to definitely talk to the sponsors about that. And just to give the public
1 minute
an idea of how long, for example, a jury selection process can last for days, right?
Correct.
Right.
Yes,
Yeah.
several days, depending on the complexity of the trial.
Exactly. So I'm going to thank you for your input, because I think you agree with me that $20 per day was too low. I also agree with you that perhaps we should, rather than having you or future people in your positions come before us over and over again, we won't be here either, to keep changing it, that we should consider that it be a floor. I think that's one of the best recommendations today. So I want to thank you for coming before us and offering, you and the other testifiers. Thank you. Thank you so much, Madam Chair.
You're
My time is up.
welcome, Senator Maurice James. Senator Johnson. Senator Blyden, you may proceed.
Thank you so much, Madam Chair. Good afternoon to my colleagues.
Good afternoon.
You and listening witnesses, staff, central staff. Good afternoon, testifiers. And thank you so much for your testimony. Some very good information, very good recommendations in terms of amendments to help strengthen the bill. First, I want to thank the sponsors of the bill for bringing it forward, Senator Novell Francis and Dan Capehart. It's a very good bill, and it's needed and necessary. It has been since 1976 that we have seen increases, and we know the importance of juries and witnesses alike. And I ask that question because in respect to witnesses, because witnesses are just as important as the juries. And Administrator Peterson, you stated it's based on who brings the cases forward. So we're gonna have to find out exactly what's going on in that space and what type of funding we're speaking out or speaking to. Let me ask though, because you also spoke, both testifiers spoke to federal employees and the bill in terms of payment for those individuals, and several recommendations were also made for those employers and for those employees when it comes to jury selection and jury duty, basically. Can you expand on that for me, please?
Regina Peterson for the Judiciary. Senator, I guess the point that we're making is that the federal government has its own set of policies regarding whether or not their employees are entitled to juror fees, and that is not well placed here in this statute because they are separate.
And in that respect, then, and knowing the importance of juries, do you see that in any way hampering the process in terms of those individuals coming forward or not?
I don't, to the extent that I believe that it is a civic duty. I don't think that they have an issue probably with service, and that's in their whatever their policies and regulations are. But there's always that concern about the potential for disincentivizing people to want to participate in the process. But it really isn't, I shouldn't say isn't a choice. Of course, I think reference was made to the days when the marshals would come out and round people up for not showing up or reporting for jury service. But we really don't want to have to use strong arm tactics. So we're in favor of any and every method or measure that would improve participation.
Okay, very well. And I believe this measure will assist in many ways in improving that process moving forward. So again, I want to thank the sponsors. I really don't have much questions. You have covered most of the bases. You have made many recommendations that will strengthen the bill, I believe. And definitely, I am not on this committee, but I will be voting I will be voting for the bill as it comes forward when it comes to the full body. And again, thank you so much for your testimony and your recommendations and your responses. Thank you so much, Madam Chair, for the time.
Thank you, Senator Marvin Blyden, non-committee member, for your line of questioning. Senator Novell Francis, you may proceed with 4 minutes.
Thank you very much, Madam Chair, and thank you to all my colleagues on weighing in on this particular measure. And I think that we have all agreed at this point that something needs to be done. And when we look at dollar value today, in 1976, $40 were $40, and in 2024, that $40 would have been $221.08. I think some reference were made back to 1957 in some instances. So, I welcome the discussion, and whatever we need to do, again, I think the courts have a responsibility to adjudicate these matters, whether it's criminally or civilly, in a timely fashion, and to ensure that there is no impediment to prohibit that from occurring. And of course, we're not saying whether there's any guilt or innocence in these matters, but rather to make sure that everyone have a day in the court to make that determination, and that's hence where we stand. So I think that there have been some very, very good suggestions made by all of the testifiers in this regards. Certainly, we knew that increasing the jury fee will require some budget adjustments, and we're willing to do that, moving forward, because it's only fair. But at the end of the day, we want to make sure that the courts in no way, if there's any impediment to them being able to get both juries and witnesses there. So thank you for that. In respect to some of the comments that have been made by the Bar Association, and the truth be told, some of these measures in terms of the discussion, really starts with the Bar Association. When we have conversation with the bar associations, especially when you have a new president that's taken over, they have these concerns that have been raised with this body, myself and Senator Capehart and others, have these discussions with them, and hence we're moving this because they see these as improvement to the judiciary. So hence why we move these measures on their behalf, really, but really benefits this community entirely. Deputy AG, thank you for your comments as well in respect to how we can strengthen this particular bill. Is there anything else that you would want to put on the record at this time in terms of how you believe that the fact that having adequate jury, a jury pool to select from, as well as the witnesses payment, how does this benefit your case in chief?
Ian Clement, Deputy Attorney General. Yes, I would say that increasing the fees would certainly diversify the jury pool. We don't want the same folks, and we appreciate those folks who take the time to serve on juries, but we want to diversify the jury pool to make sure that whether it be civil or criminal, individuals are treated fairly before the courts. And I think that diversifying the jury pool only increases that. And with respect to the witness fees, witnesses coming forward, especially in a criminal sense, it really does matter that we get more funding for that. And whether it be through the Department of Justice or through the VIPD, we desperately need, especially in the matters of witness protection, an increase in the amount of funding with respect to that, because they are instrumental in the criminal sense of bringing these prosecutions forward. And we certainly do need the help of the legislature with more funding when it comes to that.
Thank you for saying that. And in fact, when we talk about witness fees, and I know that the courts have already alluded to the fact that that's not within their purview, but certainly with the witness fees, it is a panel of the Attorney General's office, Department of Justice, as well as the police department that sits and make a determination on the disbursement, the consideration, and everything else as it pertains to witness fees, correct? Or witness protection?
Yes.
Okay. I think that that's important to put on the record as we have this discussion about the separation of whether or not we should include witnesses along with this particular measure, and I'll continue to weigh that option
1 minute.
as we go along. Bar Association, thank you for your testimony. I know that you're prepared to discuss additional measures as or additional discussion in regards to this bill in particular. Can you speak to any additional discussion that have been had by the Reform Committee in respect to your review? I mean, outside of the bar, you have already made it clear that this is not a bar decision, but however, the Reform Committee, if you could just talk about some of the angles of discussion that have been had in regards to the jury fees increase.
So for this particular bill, I was the one who reviewed it for LLR. I recently became chair of the committee, and so we've reached out, and we have 5 or 6 members now. I know that attorneys in the community, just like everyone else who's working, the capacity. May I finish?
You may conclude. Proceed.
Thank you. Capacity is limited, so it's not, discussions are not required. What I do is I send out the bills that we receive or have access to or get knowledge of, and I allow them the opportunity to input as their experience, skills, or interest allow. And so for this one particular, I was the one that looked at it, but even based on conversations that are had today, lead to additional comments, and considerations. And so these conversations are good to have early and often, and to have them more than once, because every input you hear allows for that conversation to grow and to expand, and hopefully result in bills that are as well-rounded as possible.
Again, thank you. Thank you very much for your input. And I think one thing that we can all agree on is 48 years with this measure being in place is certainly ripe for discussion and ripe for review. So certainly this is where it begins. And, we'll see where it goes from here. I'm hoping that my colleagues could see to move this on to the next level, and the recommendations, which I think is clear and concise, that have been made by the testifiers, we could put into an amendment so they could be addressed at the next level. Thank you very much, Madam Chair, for the time and opportunity.
You're welcome, Senator Francis. Senator Johnson, you may proceed with 4 minutes.
Good afternoon. Thank you very much, Madam Chair. I don't think I might need 4 minutes. I support this wholeheartedly. I really applaud my colleagues for this measure, but I want to go a little different direction with my line of question, because what I want to ask the court is, what measures do you use? Because I think you got some tools in the court for those who are not responding to your requests, and how often do you utilize those tools to make sure for those people who ain't responding, the no-shows, what are you doing about those folks?
Good afternoon, Regina Peterson. Senator, that's really a question for our judicial officers. I think by stroke of luck, we've managed to impanel juries for cases. And I think that, yes, we do have the ability to send out the marshals. The process is generally that if we don't have sufficient jurors, our jury management staff will reach out gently. And then if we run into a situation where we may have two trials that we're trying to impanel a jury for, and we don't, and the numbers are not there and calling doesn't work, then they can certify a list of jurors who failed to show to the judge, and the judge can then issue an order for them to be brought before the court.
I think I
show cause why.
I think I operate with a heavy hand a little bit sometimes, but I think
yes, you do.
I would like to see that being utilized a little bit more, because what I think we're going to be experiencing, that I'm quite sure you are, you keep having the same pool and the same group of people over and over, and it's a little unfair to those who are willing, and we appreciate them, that's for sure. But members of the community or members of that you are sending these letter of requests needs to know that it's really like you don't have a choice, that you could just do what you want. It's the law. And there comes the consequences for not complying. I'm not saying to lock up anybody, but I think we need to really exercise that right that you guys have and start sending them out. I did some work with the district court, and I can recall the marshal them going out right in Sundays and just bringing folks in. Pick them up, bring them in. Not even some of them that didn't show up, but those that didn't show up. And I've seen, Judge Alma Lewis and Judge Fitch send the marshal for folks who have not been responsive or responding. So I would like to see that the court will start at least reaching to those folks who have not continuously just not responding, not filling out the form, or so that we can have that bigger pool. But at the appropriate time, I definitely will be supporting this measure. And I've been in high school in 1976, and I can't tell some of my teacher's name right now. So that's how long ago it's been this price, and the cost of living, everything have risen drastically, and I can see the problem that you will be having getting people to just show up, because folks who have a minimum paying job and the jobs don't compensate them, they have the children, they have everything else to do. So it's very difficult. So I really applaud my colleagues them for this measure, and at the appropriate time, I definitely will be voting in the affirmative to carry it forward. And once it reaches to the next stage, I definitely will be supporting it. So again, thank you very much. I have no further questions, just asking for the courts to do a little strong arm, a little bit, start making people be accountable and responsible citizens and respond to your requests. Thank you very much, Madam Chair.
Thank you, Senator Johnson. You did need 4 minutes. Senator Johnson, thank you for your line of questioning, because you've been in that arena and you understand. I just want to ask this question as Senator Novell Francis and I bring this measure to this body. Is this, which is great, there's a need to increase the pool, but I was kind of thinking outside the box, and you guys could shoot me down. What about, because I think once you register to vote, that is where you get the pool of individuals. Is that correct? Administrator Peterson?
Good afternoon again, Regina Peterson. We use the election rolls as well as the driver's license.
Oh, that's what I was going to ask, if we could use the driver's license. Okay, so you already tap into that pool of Virgin Islanders who register to drive on our roads. You use that pool of individuals. Okay.
That is
well. Thank you. So you didn't have to shoot me down. It's already being done. Thank you. So colleagues, we have actually concluded the first round of questioning. Are there any other burning questions to be asked? Hearing none, at this time we'll take a short recess. 2 minutes. Committee stands in recess, 2 minutes.
The Committee on Rules and Judiciary is back on the record. Do I hear a motion? Do I hear a motion? Are y'all hearing us in St. Croix?
Motion. Senator Capehart.
Senator Capehart, you're recognized for your motion.
Thank you, Senator Potter. I move Bill number 35-0121, an act amending Virgin Islands Code, Title 4, Chapter 29, Section 482, and Title 5, Subtitle 1, Part 5, Chapter 61, Section 660, increasing jury and witness fees and allowances, respectively, be forwarded to the full body for full consideration. I so move.
Do I have a second?
Second.
Properly moved by Senator Capehart, seconded by Senator Johnson and Senator Bolkes and Senator Gittins. Roll call on bill number 35-0121.
Senator Angel L. Bolkes Jr.
Yay.
Senator Bolkes Jr. Yay. Senator Diane T. Capehart.
Yes.
Senator Capehart yay. Senator Kenneth L. Gittins.
Yes.
Senator Gittins yay. Senator Maurice C. James.
Yes.
Senator James yay. Senator Franklin D. Johnson. Senator Johnson yay. Senator Carla J. Joseph. Senator Joseph absent. Senator Milton E. Potter.
Yes.
Senator Potter yay. Madam Chair, you have 6 yeas, 1 absent. Chair, sorry, Mr.
Thank you
Chair.
very much. I won't hold that against you. Thank you very much, Madam Clerk. Colleagues, Bill number 35-0121, an act amending the Virgin Islands Code, Title 4, Chapter 29, Section 482, and Title 5, Subtitle 1, Part 5, Chapter 61, Section 660, increasing jury and witness fees and allowances, respectively, has been voted upon favorably in the Committee on Rules and Judiciary and will be forwarded to the full body for further consideration. I will, before we finalize, before we release the testifiers, I'm going to give you an opportunity to do a wrap-up, a 30-second wrap-up, beginning with the acting AG and moving forward.
Ian Clement, Deputy Attorney General, Department of Justice. I would just like to just restate that it is important for the administration of justice that we have a diversified jury pool, not only for civil cases, but especially for criminal cases, so that individuals charged with crimes are really afforded a trial by a jury of a cross-section of their peers. This bill will aid in helping to bring more people into the fold as far as not throwing away their jury requirements or the jury summonses and get them into the jury pool. And the Department of Justice certainly wholeheartedly supports it. Thank you.
Thank you very much, Attorney Clement. Administrator Dishabir Peterson.
Good afternoon, Regina DeShabir Peterson. Once again, I would like to thank the committee for the opportunity to testify in favor of a fee increase for juror service, subject to some of the technical amendments that we raised, of course. And I will once again plug giving us the authority or flexibility, look at it as a floor, not a ceiling, so that we can make the necessary adjustments. We're the ones issuing those payments on a regular basis and experiencing the challenges with the jury pool to allow us the flexibility to make those adjustments. And it's not just the fees alone, it's the transportation adjustments, transportation to and from St. John, transportation to and from Water Island, and make those adjustments based on what those actual expenditures are so that people don't feel disenfranchised. closed. So once again, I thank you for the opportunity to provide input on this very important piece of legislation, and I look forward to this body funding the increase.
Thank you very much, Ms. Dishabir Peterson. Attorney McKinney, yes, you may move forward with your 30 seconds.
Attorney Jessica McKinney, Chair Legislation Law Reform Committee. Words matter, especially when written in law. So it is helpful to consider the current and future implications of specific terms as well as specific fee amounts being included in the law to help you all pass a law that's going to be well-rounded and help the needs now and in the future.
Thank you very much, Attorney McKinney. Testifiers, unless you are slated to be here for the next bill, you are officially released from your responsibilities here this afternoon. The Committee on Rules and Judiciary stands in recess for 2 minutes.
I'm sorry, that's my Wheaties I ate. Colleagues, we are now in Block 3. And I would ask who speaks on Bill number 35-0174. Senator Francis, you may proceed.
Thank you very much, Madam Chair. Bill number 35-0174 is an act repealing and reenacting the Title 15, Virgin Islands Code, Article 5, Parts 1, 2, 3, 4, enacting Part 5 and renumbering Parts 4A as Part 6 to repeal the Uniform Guardianship and Protective Proceedings Act and enact a new Uniform Guardianship, Conservatorship, and Protective Arrangement Act with amendments and for other related purposes. When I first filed this bill draft, my intention was only to address the concerns brought forward by the Virgin Islands AARP specific to our elderly community. I knew these concerns would be valid because we hear the heartbreaking stories all the time where gaps in the existing statute create challenges when it comes to taking care of our aging or unable parents and relatives. However, upon a closer review of the statute enacted in 2016 and the recommendations of the legislature's legal counsel, it became apparent that the best approach of this bill was to update the existing Guardianship and Protective Proceedings Act to ensure compliance with federal guidelines, but mostly important to support the least restrictive means necessary for protection of individuals, both minors and adults, who cannot care for themselves. In the 2020 census found that 21.3% of our population is age 65 or older, and 1.8% is 85 years and over. Our vulnerable population also include minors. The latest kids count reported show that 33% of the Virgin Islands children live in poverty. An aging population, vulnerable minors who are in environments that are not safe and stable, and persons who may not be able to care for themselves require specific policy considerations. This is a big bill, over 124 or so pages, and I don't want anyone to be deterred by its size. If we limited our revision to the adult guardianship section only, we would leave gaps through references to provisions that are not currently in the code. By repealing and replacing the existing statute with the new Uniform Guardianship, Conservatorship, and Protective Proceedings Act, we are creating greater clarity in the law. For example, by describing the current circumstances in which a conservatorship, guardianship, or protective arrangements may be needed for a child, and the circumstances that may decide which option may be best serve an individual. Bill number 35-0174 allows the Virgin Islands to conform with the Uniform Law Commission and join in the growing numbers of states that are taking proactive measures to best meet the needs of our community we serve. My thanks to our testifiers, to include the ARP, the Virgin Islands Bar, the Uniform Law Commission, the Department of Human Services, for their insight and participation. Thank you very much, and I ask for my colleagues' support on this measure. Thank you very much, Madam Chair, for the time and opportunity.
Thank you, Senator Francis. Madam Clerk, are there any correspondence to be read, any testimonies to be read into record?
Yes, a testimony.
Please proceed.
35th Legislature, Committee on Rules and Judiciary, testimony on Bill number 35-0174. Good day. My name is Attorney Julie S. Todman, and I am the Chief Territorial Public Defender for the U.S. Virgin Islands. First, I extend thanks and gratitude to each of you, the members and staff of the Committee on Rules and Judiciary of the 35th Legislature, especially to Senator Diane T. Capehart for inviting me to testify today. I also thank Senator Novell E. Francis, Jr. for sponsoring this bill and requesting Office of the Public Defender's feedback. I am testifying on behalf of the Office of the Territorial Public Defender on proposed bill number 35-0174, which is an act repealing and reenacting Title 15, Virgin Islands Code, Article 5, Parts 1, 2, 3, 4, enacting Part 5, and renumbering Part 4A as Part 6, to repeal the Uniform Guardianship and Protective Proceedings Act and enact the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act with amendments and for other related purposes. The Office of the Territorial Public Defender has insight into the area where guardianships, conservatorships, and criminality intersect and interact. This is true because while most guardians do the right things for the right reasons, when guardians commit acts of abuse and exploitation, the impact can be tragic and unimaginable, and often leads to criminal charges. American Bar Association, Challenges in Guardianship and Guardianship Abuse, March 11, 2021. My office is not involved directly in guardianship proceedings, as the agency tasked with the represented indigent persons accused with crimes. Our interaction with the courts regarding Bill number 0174 will be where the process breaks down and someone is arrested. Bill number 0174 does not directly provide for those situations. Any criminal actions will be under Title 14, the Criminal Code. If implemented, Bill number 35-0174 should reduce expenses, increase accountability, reduce crime, clarify rights, and reduce court backlogs. Bill number 35-0174 provides a comprehensive framework for the uniform processing and handling of guardianships, conservatorships, and other protective arrangements. These protective arrangements are utilized to reduce victimhood and prevent tragedy. Bill number 35-0174 should eliminate confusion and unnecessary conflict by detailing safeguards and mechanisms for intervention by non-parties. Disputes are common between those accepted by the court, which we refer to as parties, and all other non-parties. Providing availability to the system by non-parties is critical because parties and non-parties fighting amongst themselves is exactly the type of dispute which might ultimately lead to trouble and possibly OTPD involvement. Bill number 35-0174 should improve this by streamlining the involvement of the court and providing clear rules and laws for non-lawyers to follow and understand. Sometimes, the lack of clarity in cases involving a protected person sparks resentment, outrage among family members and friends, and can even lead to criminal acts. This could conceivably lead to violence, often domestic violence in this context, and usually occurs when a family needs most to rally together rather than be torn apart. By clarifying the process and identifying the rights of parties, family members, and interested non-parties, Bill number 35-0174 seeks to prevent hostile and combative interactions amongst interested people as it provides a framework for obtaining notice about proceedings, a process for filing a grievance, identifies and provides a basic for the court to handle repetitive grievances. Indeed, notable bill components include Bill number 35-0174, 5-105 provides for transfer of the proceedings upon the court's determination that transfer is in the best interest of the individual subject to guardianship. Bill number 35-0174, 5-125 provides a process for uniform registration of guardianships issued in other jurisdictions and allows for the registering of the foreign guardianship by filing an order granting guardianship as a foreign judgment here in the Virgin Islands. Bill number 35-0174 provides that non-parties can file a request for notice 5-116. This allows interested people to be part of the process and to receive direct notice, hopefully reducing interactions which might become hostile. Bill number 35-0174 provides for letters of office 5-108, which can identify and limit powers. Bill number 35-0174 provides clarification that co-guardians and conservators shall make decisions jointly, 5-110. Bill number 35-0174 provides a mechanism for filing of grievances, 5-127. We believe that this provides clarification and a method for involvement and review by the court that eliminates possible conflict. Section 5-127C also provides limits on grievances that prevent additional similar grievances within 6 months. Section 5-203C requires that notice of hearing for appointment of guardian for minor must be served on all adult siblings, grandparents, and those having primary care or custody of the minor for at least 60 days within the last 2 years or at least 730 days during immediate prior 5 years. Taken together, these provisions could hopefully eliminate disputes and along with that, the need for OTPD involvement. Impact statement on vulnerable populations. OTPD believes that this act will have the following impacts. Protection. The bill aims to protect vulnerable individuals such as minors and adults who require guardianship or conservatorship. It encourages courts to use the least restrictive orders necessary to adequately protect these individuals. Adaptability. The bill allows for continuous adaptation to an individual's changing capabilities, and needs. This means that as the situation of the vulnerable individual changes, the protective arrangements can be adjusted accordingly. Accountability. The bill imposes clear duties on guardians and conservators who are charged with protecting others. Regular monitoring is required to ensure these individuals are fulfilling their responsibilities appropriately. Rights preservation. The bill allows courts to address specific problems with limited orders, preserving individual rights when possible. This means that the rights of the vulnerable individual are considered and protected to the greatest extent possible. Conflict reduction. By detailing safeguards and mechanisms for intervention by non-parties, the bill aims to reduce conflict and confusion. This can be particularly beneficial in situations where family members or other interested parties may have differing opinions on the care of the vulnerable individual. Expense reduction. The bill aims to reduce expenses associated with guardianship and conservatorship cases. This could potentially make it more accessible for vulnerable individuals to receive the protection they need. Conclusion. Overall, Bill number 35-0174 will modernize the law and provide a comprehensive framework for the uniform processing and handling of guardianships, conservatorships, and other protective arrangements. This ultimately benefits vulnerable individuals by ensuring they receive the protection and care they need in a manner that respects their rights and individual circumstances. Madam Chair, that's the end of the testimony.
Thank you for the reading of the testimony for Attorney Julie Todman, the Chief Public Defender. We have 3 individuals who are doing their testimony virtually. I would like to first start with the VI State Director, Troy Schuster, to proceed. I think you should just identify yourself, your name, so we could do that testing to make sure everything sounds good. When you're finished identifying yourself, saying your name, we would go to Attorney Tom Bolt and then Attorney Ben Orzeski. So you may proceed, Mr. Schuster. Just your name.
Thank you, Senator Capehart. This is Troy Deshabir Schuster, State Director for AARP in the Virgin Islands.
Thank you. Attorney Bolt?
Tom Bolt, Chair of the Virgin Islands Uniform Law Commission.
Thank you. Attorney Ben Orzeski?
Yes, thank you, Chair Capehart. Ben Orzeski, Chief Counsel with the Uniform Law Commission.
Okay. On St. Croix, we have Assistant Commissioner Carla Benjamin. State your name.
Good afternoon, Carla Benjamin, Assistant Commissioner, VIDHS.
Okay. On St. Thomas, we have 2 testifiers. If you can please identify yourself. Please acknowledge the mic, starting with Administrator Peterson.
Courts for the Virgin Islands Judiciary.
Attorney McKinney, Chair of the VIBA Legislation and Law Reform Committee.
Thank you. So colleagues, we're going to begin the virtual testimony, starting with VI State Director of AARP, Mr. Troy Schuster. You may proceed with the reading of your testimony.
Thank you. Honorable Senator Diane T. Capehart, Chair of the Committee on Rules and Judiciary, members of this committee and senators of the 35th Legislature, AARP in the Virgin Islands wishes to express our deepest gratitude for the opportunity to provide comments on a matter of increasing national concern: guardianship of older adults and individuals with disabilities. This issue exposes a very vulnerable population to potential risks such as abuse, neglect, and exploitation. As an organization dedicated to empowering individuals as they age, AARP and AARP here in the Virgin Islands urges your committee to champion enhanced oversight of guardianship by adopting the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act, otherwise referred to as ARCOPA, in the U.S. Virgin Islands. Guardianships and conservatorships are legal arrangements that allow one person, the guardian or conservator, to make important decisions on behalf of another individual who is unable to make those decisions for theirself. These arrangements are put in place to protect and ensure the well-being of individuals who may be incapable of managing their own affairs due to age, physical or mental disability, or other types of illness. Guardianship involves decisions related to personal matters such as healthcare, living arrangements, and education, while conservatorship focuses on the management of financial matters and assets. Through guardianship and conservatorship, individuals who are vulnerable and in need of support can receive the guidance and protection necessary to live a secure and fulfilling life. These legal mechanisms aim to safeguard the best interests of those who are unable to do so themselves, ensuring their rights and dignity are respected. As the largest nonprofit and nonpartisan organization in the United States, with our local membership of nearly 21,000 members and our nationwide membership of 38 million, AARP has a long and distinguished history of advocating for issues that profoundly impact older adults and their families. For the past 7 years, AARP Virgin Islands has spearheaded the movement for guardianship system reform. recognizing the role it plays in safeguarding the rights and well-being of older or disabled Virgin Islanders. As a matter of fact, the act that we are hoping to have repealed was put forth by AARP, the Uniform Law Commission, and Attorney Tom Bolt, our Uniform Law Commissioner here in the Virgin Islands. And now this one is an upgrade, if you will, of that. Our efforts have resulted in the establishment of standards and training for guardians, protection of the rights of those under guardianship, combating abuse, and bolstering court oversight of guardians and conservators. While we have achieved significant strides, there is much work that remains to be done. Our aim for this bill is twofold: to establish both procedural and substantive safeguards that protect individual rights, and to protect incapacitated and vulnerable adults so that they may live with dignity and respect. Guardianships are inherently complicated. The current guardianship system has significant shortcomings, leading to more than 16 states enacting 37 new laws on adult guardianship in 2021. In the first 9 months of 2023, 24 states adopted 46 new laws aimed at mitigating the potential for abuse. Presently, there are approximately 1.3 million active adult guardianship cases in the United States, amounting to an estimated $50 billion in assets. This includes a number of cases specific to the Virgin Islands. The enactment of the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act signifies a revolutionary reform addressing these challenges with a balanced approach that prioritizes both protection and empowerment. This act sets forth a framework for safeguarding individual rights while maintaining necessary legal oversight and accountability of those put in positions of authority. The proposed bill number 35-0174 moves the Virgin Islands toward the meaningful reform aligned with the principles of ACOPA by improving the right to the appointment of qualified counsel, establishing clear decision-making standards for guardians, and advocating for the expression of the client's own decisions by any supportive or substitute decision maker. Beyond the need to reform the system, we must also consider less restrictive alternatives to full guardianship. Alternatives would afford individuals the right to retain their decision-making powers concerning the overall well-being and livelihood. ACOPA places the rights of individuals at the forefront, ensuring that guardianship becomes the last resort rather than the default option, ultimately leading to better outcomes for all parties involved. There have been instances both across the United States and in our territory where older adults under the current system are at risk of future complications, including abuse. Elder abuse refers to actions or negligence that cause harm or risk to an older adult. Unfortunately, it is often perpetrated by individuals entrusted with their care. These situations starkly illustrate the reality faced by many Virgin Islanders. In a recent 2022 survey, more than 48% of Virgin Islanders identified elder abuse as a major problem affecting older adults in our community, further underscoring the need to safeguard and protect their well-being. Fundamentally, ACOPA seeks to protect individuals from abuse. For this reason, AARP Virgin Islands wholeheartedly supports this legislation, recognizing its potential to create a more efficient and more fair system for older Virgin Islanders. We urge you to continue making strides in safeguarding the interests of Virgin Islanders by advancing Bill number 35-0174, the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act. This would enable us to honor the civil rights of those whose care is entrusted to us. On behalf of AARP and the Virgin Islands and its 21,000 members here, I wish to thank Senate President Novell Francis, Senator Marvin Blyden, and Senator Angel Bolquez for their sponsorship of this bill, and the Honorable Senator Diane Capart's invitation to testify to this Committee on Rules and Judiciary. AARP stands ready to work with you to strengthen the Virgin Islands guardianship system. Thank you.
Thank you, the VI State Director, Troy Schuster, for your testimony before this body today. Next, we will go to Attorney Bolt, who is no stranger to this legislation. For Uniform Law Commission, you may proceed with your testimony.
Thank you, Madam Chair. Members of the 35th Legislature's Committee on Rules and Judiciary, senators, legislative staff, ladies and gentlemen, I'm Tom Bolt, and I'm chair of the Virgin Islands Uniform Law Commission. And I thank you for this opportunity to appear before you today with respect to bill.
We don't know what's happening.
Like he lost his connection.
We'll take a quick 2-minute recess. The Committee on Rules and Judiciary is out of recess. Attorney Bolt, I don't know if you're still experiencing technical difficulties, but we will, in the meantime, proceed with Attorney Ben Orzeski, the Chief Counsel for Uniform Law Commission.
Thank you, Chair Capehart and members of the committee. Thank you to Senator Francis for introducing this important legislation. The bill before you represents the Virgin Islands enactment of the Uniform Law Commission's latest act on guardianship. It would replace a current law also based on a previous Uniform Act on guardianship. That Uniform Act now in place in the Virgin Islands is 27 years old. The Uniform Law Commission approved that version of the Uniform Guardianship and Protective Proceedings Act back in 1997. A lot has happened in guardianship law reform in the intervening 27 years. The committee that drafted this latest version that's before you today heard from a lot of stakeholders representing older Americans, Americans with disabilities, representing probate judges and probate courts and attorneys, representing guardians, both family guardians and professional guardians. They heard why the current system was failing those that it was intended to serve. And the bill before you would address many of those failures. For instance, under most states' current law and under the law that's in force in the Virgin Islands, a person who is going to be subject to guardianship is not necessarily even going to attend the hearing and have an opportunity to testify on their behalf. They're not necessarily going to be represented by an attorney. They're not necessarily going to have the right to appeal decisions once the court issues guardianship and places them under guardianship. Indeed, the average adult who is subject to guardianship has fewer rights than a convicted felon. That's not right, and this is an issue that needs to be addressed by the legislature in the Virgin Islands and in states across the U.S. That's what's happening with the current version of this Uniform Act. It's been adopted so far in 2 states and is in process in several more. There were bills introduced in 5 states this year. It's a slow process. This is a complicated area of the law and one that where significant reform is needed. I want to address some of the potential costs and benefits of implementing this new law. There is a need for greater due process protections for those who are subject to guardianship. And that means under this new law, guardians and those who are proposed to be appointed guardian will have more work to do. They'll have to compose an individualized plan that outlines the subject of the hearings, both their needs and their abilities, in order to for the court to be able to draft an individualized guardianship order that's no more restrictive than necessary, and yet will meet the needs of the person, make sure that they are safe and healthy and can live the best life possible. We do ask each court to spend a little bit more time on each case, but recognizing that courts have limited resources, the drafters of this Uniform Act also implemented significant opportunities for savings. And that is most apparent in the addition of new Article 5 of this Uniform Act on other protective arrangements. This gives courts the ability to take a petition for guardianship, and if the analysis shows that the person who is the subject of the hearing does not need a full guardianship, but could be served with a limited guardianship or with a less restrictive arrangement, such as a supported decision-making agreement or power of attorney, it allows the court to be creative with its solutions and to implement these less restrictive solutions that will divert a significant number of cases out of the guardianship system entirely, requiring no ongoing monitoring and saving the court valuable resources over time. I thank the committee for considering this issue, and I'm going to stand by after testimony to field any questions that members of the committee might have about this legislation. Thank you very much.
Thank you, Attorney Orzeski. Am I pronouncing your name correct? Good?
You're pronouncing it perfectly. Thank you, Chair
Okay,
Capehart.
thank you. Attorney Bolt, are you still there?
Yes, ma'am, I'm still here.
Okay, good. You may proceed.
Well, I guess, I'd start at the beginning and just thank you for the opportunity as chair of the Virgin Islands Uniform Law Commission to appear before you today. As I was saying, since departing the legislature as its counsel, a significant amount of my private practice has concentrated on estate planning. Every week, I have Virgin Islanders calling my office seeking powers of attorney, guardianships, conservatorships, and our population is growing older, and the guardianship law throughout the United States has advanced dramatically to protect the rights and interests of persons determined by our courts to need help caring for themselves since the original Uniform Law on Guardianship was promulgated in '69, revised in 1982 and 97. And I believe that we then enacted the last Uniform Guardianship Act back in 2016. Bill 350174 is part of an overall effort that this legislature and previous legislatures over the course of the past 15 years have tried to modernize our probate, guardianship, and estate planning laws. We've done this through the adoption of various elements of the Uniform Probate Code, and we have adopted now Article 1, which are general provisions and definitions. Articles 2 on intestacy and wills. Article 3 on procedural rules of probate. And Article 4 on wills and intestacy outside the territory are subject to another bill, which, as chair of the Virgin Islands Bar Association's probate law committee, we completed work on this earlier this year, and a team of with a team of Virgin Islands lawyers, and reported a final bill to the Bar's Board of Governors, which transmitted the same to Chief Judge Reese Hodge for review. I believe that that heart of the probate code 2, 3, and 4 is pending before this legislature, and there's been a bill request has been entered for that, and hopefully it will be coming before you in the not too distant futures. Today, I do not speak today on behalf of the bar, but as chair of the probate law committee, but Jessica McKinney, chair of our Virgin Islands Bar Association Legislation and Law Reform Committee, will speak later today. Article 6 of the Uniform Probate Code concerns non-probate transfers, and we spent considerable time here adopting many of those non-probate transfers, and these were previously adopted by previous legislatures. The legislation before you today was drafted by guardianship experts. Organizations that are involved in the drafting process included AARP, which Troy DeShepard spoke earlier, the Alzheimer's Association, the National Guardianship Association, the National Center for State Courts, the National College of Probate Judges, the ARC, which is an organization that promotes and protects human rights of people with intellectual and developmental disabilities, the American Bar Association's Commission on Law and Aging, the National Academy of Elder Law Attorneys, and the National Disability Rights Network all had a handle in drafting the bill before you. It fulfills many of the recommendations of the 2011 Third National Guardianship Summit and the National Guardianship Association Standards of Practice by providing that individuals that are subject to guardianship and conservatorship proceedings remain at the center of all considerations and decisions. The Act requires courts to avoid appointing a guardian or conservator if there are less restrictive alternatives, such as supported decision-making or limited protective arrangements that provide adequate protections. UCOPA protects key legal rights of persons subject to guardianship or conservatorships, including the right to receive independent legal counsel and the right to have the order modified or terminated when appropriate. It respects and ensures the rights of persons subject to guardianship and conservatorship to receive visits or communications from family and friends as they so desire. At the same time, it provides guardians and conservators clear standards for making decisions that keep the person subject to the guardianship at the center of their decision making. Bill number 350174 encourages this person-centered planning in which a guardian or conservator must develop an individualized plan for each person's protection. Family and friends will receive copies of the plans, and courts monitor the guardian or conservator for compliance. In short, it promotes independence and does not impose a guardianship or conservatorship if less restrictive alternatives, such as supported decision-making, would provide adequate protection. It empowers our Superior Court Family Division to create a mechanism whereby our family court judges can order a protective arrangement instead of a guardianship or conservatorship when a person needs can be met through these less restrictive options. Furthermore, it helps leverage precious court resources. Courts can require notice of certain suspect actions to be sent to family members or friends of a person subject to a guardianship who can serve as the court's eyes and ears to prevent abuse. This legislation also protects legal rights, such as the person subject to the guardianship or conservatorship order must be given notice of certain key rights, including the right to receive independent legal counsel and the right to have the order modified or terminated when appropriate. Guardians and conservators are limited in their ability to charge fees to oppose the alteration or termination of orders. Bill number 350174 provides clear guidance to guardians and conservators, including, as I mentioned before, a list of applicable fiduciary duties and clear standards for making decisions. Another unique aspect of the law is that it helps prevent isolation. A guardian may not restrict family members and friends from visiting or communicating with a person subject to guardianship for more than a week without a court order. Unless the court orders otherwise, the guardian is required to notify interested persons of any change in residence or significant change in health status. As discussed earlier, Bill 350174 is part of our larger plan. And by this and previous legislatures to amend Title 15 of our Virgin Islands Code to bring our probate, guardianship, and estate planning laws into the 21st century. While this legislation is direly needed, I strongly suggest that the legislature consider adding a delayed effective date of not sooner than January 1, 2025 to give the bench, the court administration, and the bar, the attorneys, the opportunity to receive continuing legal education and to prepare for implementation of this important legislation. You've already heard from Ben Orzeski, who is Chief Counsel with the Uniform Law Commission, and he can help address any specific provisions or concerns that the committee or the members of the 35th legislature may have. One other thing that I note that came up in an earlier conversation today, and that is I was speaking with Jessica McKinney with the Virgin Islands Bar, and on interpreting these provisions, the other thing I think that we should consider, and most states do this, and that is to do a non-code provision to this that provides that the official commentary of the Uniform Law Commission be not in the law, but it be in the annotations in our Virgin Islands Code annotated, that they be part of the annotations. And I would hope that they could do something like this. I think it would help the bench and the bar in their interpretations of the actual what will be in the code. In the meantime, if I can address any concerns, I welcome your any questions you may have. Thank you.
Thank you, Attorney Bolt. And now we'll go to testifier on the island of St. Croix. We have Assistant Commissioner Caller Benjamin. You may proceed. From the Department of Human Services, I didn't say that. You may proceed.
A pleasant good day, Honorable Diane T. Capehart, Chair of the Committee on Rules and Judiciary, Honorable Milton E. Potter, Vice Chair, committee members, other senators present, and the listening and viewing audiences. I am Carla Benjamin, Assistant Commissioner for the Virgin Islands Department of Human Services, testifying on behalf of the Honorable Avril E. George, Commissioner Designee. I am pleased to be invited to provide testimony on Bill number 35-0174, an act repealing and reenacting Title 15, Virgin Islands Code, Article 5, Parts 1, 2, 3, 4, enacting Part 5 and renumbering Part 4A as Part 6, to repeal the Uniform Guardianship and Protective Proceedings Act and enact the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act with amendments and for other related purposes. The department supports the intent of this very important bill, which seeks to provide protections for our vulnerable citizens who cannot fully manage their own affairs, while simultaneously securing a measure of autonomy and self-determination for those same individuals. However, there are a few minor revisions and areas of concern from the VIDHS's perspective. We believe that the proposed definition of parent on page 3, line 21 of the bill, captioned in section 5-102, paragraph 21, which currently reads, parent does not include an individual whose parental rights have been terminated, is too broad as it provides no definition of a parent, only references the exclusion. We recommend the definition of parent, which is already captioned in Title 5, 2502, paragraph 21, which reads, parent means the father or mother of a child and includes any adoptive parent. It does not include a person whose parental rights in respect to the child have been terminated in any manner provided by the law, be utilized as it provides a more comprehensive definition of who is a parent and excludes the requisite exclusion. Additionally, on page 16, line 5, references a report made to the Department of Human Services Division of Children, Youth, and Families. After of, delete Human Services Division of Children, Youth, and Families and insert Human Services. The Division of Children, Youth, and Families no longer exists by that name. Simply, the Department of Human Services will encompass the Child Protective Services and Adult Protective Services divisions that address protection issues across the lifespan. We have concerns with reference to page 24, lines 8 through 24, and page 25, lines 1 through 4, which is section 5-24, attorney for minor or parent. Notwithstanding the minor or parent's right to secure legal representation, we believe that legal counsel should be appointed to minors and parents even if they do not request representation or do not object to the guardianship. In light of the fact that the legislation now empowers minors from the age of 12 years old, we do not believe that they should be required to request legal representation. Similarly, as parents may not fully be aware of the repercussions of guardianship, parents who do not object should be provided with legal counsel to ensure that they are fully informed about the proceedings. Page 33, lines 14 and 15, section 5-210D says, a guardian for a minor may consent to the marriage of a minor if authorized by the court. This provision is in direct violation of Act 8459, which ended child marriage in the U.S. Virgin Islands. It struck 4 VIC Chapter 11, Section 172E, divesting the court of jurisdiction over judicial consent for marriage of a child. This provision is a violation of 16 VIC Section 36, issuance of marriage license to minors prohibited, which reads, if upon the examination prescribed by Section 35 of this chapter, it appears that the applicant is under 18 years of age, the court shall not, under any circumstances, issue a marriage license. We recommend that this paragraph be deleted. Page 30, lines 10 through 16, which is Section 5-208, Emergency Guardian for Minor, introduces appointment of an emergency guardian by the court on the grounds of preventing substantial harm to the minor's health, safety, or welfare. The department objects to every instance where such authority is given the court without the associated requirements to ensure that the minor is not being placed under the authority of an unsafe person or in a home with unsafe persons. The department already has statutory responsibility to step in to ensure the health, safety, or welfare of minors, and has the added responsibility of conducting NCIC fingerprint background criminal checks, sex offender registry checks, and child abuse registry checks in order to reasonably assure the safety of minors. The court should be required to ensure a similar level of due diligence if intervening in lieu of the department. In closing, I thank you again for this opportunity to provide testimony. I extend thank yous to my executive branch colleagues, as well as the Honorable Governor Albert Bryan Jr. and the Honorable Tregenza A. Roach Esquire. We at DHS will continue to live out our commitment to working together to make a difference for the people of the Virgin Islands. Thank you.
Thank you, Assistant Commissioner Carla Benjamin. Now we'll proceed to the island of St. Thomas, beginning with Administrator Regina Peterson. You may proceed.
Good day, Chairman Capehart, members of the Committee on Rules and the Judiciary, and other members of the 35th Legislature present, staff of the Legislature, and the listening public. I am Regina DeShabir Peterson, Administrator of Courts of the Judicial Branch of the Virgin Islands. I would like to take this opportunity to thank the committee and the bill's sponsors, Senator Novelli Francis, Angel Bocas Jr., and Marvin A. Blyden, for the opportunity to appear before you and provide a brief statement concerning Bill number 350174. As the Administrator of Courts, responsible for the day-to-day non-judicial operations of the branch, I will try to limit my comments to any financial or operational impact on our courts. The judiciary understands that the Uniform Guardianship, Conservatorship, and Other Protective Measures Act, UGCOPA, is a model statute encouraged to be adopted by the Uniform Law Commission, whereas the original 2007 Adult Guardianship and Protective Proceedings Jurisdiction Act was widely adopted in 49 jurisdictions, including the Virgin Islands, which passed Bill 310184 in 2017. The repeal of the 2017 guardianship laws and proposed replacement has been adopted by just 2 states, with the legislation also introduced this year in 5 other jurisdictions, including the U.S. Virgin Islands, as shown in the map included in this testimony. However, the current bill is not just a revision in Virgin Islands law, as I emphasize, but a repeal and full-scale replacement of existing law. Based on the current rate of adoption, there really is not a lot of information on the pros and cons on implementation or any substantial best practice data. Accordingly, my comments again will be limited to potential cost implications for judicial branch operations as opposed to process as follows. The current bill's adoption will result in substantial increases in costs associated with court-appointed counsel and other judicial resources for mandatory hearings. The Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act, adopted by the Territory in 2017, pursuant to Act 7958, had just 3 instances of mandated appointment of counsel, generally directed to be paid from a respondent's estate. However, it's also important to note that in most instances, there is not usually a substantial estate to cover reasonable fees. By comparison, Bill 350174 proposes to adopt the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act and has 12 mandates for the court to appoint counsel, 2 of which require court-appointed counsel for parents of a minor, and 2 which stipulate that the appointment of counsel for an adult respondent should be made regardless of ability to pay. Section 204 of UG COPA covers both the right to retain counsel and the right to have an attorney appointed by the court. However, subsection E in the uniform law was placed in brackets as an option, recognizing that jurisdictions need to weigh the benefit of representation to protect parents' fundamental rights and interest in parenting their children against fiscal constraints. The 2017 enactment of the 1997 Uniform Law, pursuant to Bill 310184, also known as Act Number 7958, allowed much more judicial discretion for determinations on the need for court-appointed legal representation for parties in guardianship matters. That discretion should not be removed from judges. Section 305 of the UG COPA provides 3 options for appointment and the role of attorney for adults, 2 of which I will refer to here. Alternative A states the court shall appoint an attorney to represent the respondent in a proceeding for appointment of a guardian for an adult if 1, the respondent requests an appointment, 2, the visitor recommends an appointment, or 3, the court determines the respondent needs representation. Alternative B states, unless the respondent in the proceeding for appointment of a guardian for an adult is represented by an attorney, the court shall appoint an attorney to represent the respondent regardless of the respondent's ability to pay. It is unclear why alternative B was selected in section 5-406 of the bill. And unlike the election for minors under 5-204, this section places a mandate on the courts to appoint counsel without regard to indigency. Such mandates are challenging both from a funding and attorney resource standpoint, as we currently have just 9 attorneys on our voluntary panels for juvenile and guardian ad litem cases territory-wide. I must also note, however, that in reviewing the legislative comments to the UG COPA, it is stated that if a jurisdiction opts for alternative B, as in the current bill, then it should not include the provision from Section 304D1 of the Act requiring a visitor to recommend whether an attorney should be appointed to represent the respondent. This provision, however, appears to be included at 5-504E1 and may be an indication that the bill in its current form may require further review for consistency. The mere fact that UG COPA provides options in adoption is a clear indication that there is not or should not be a one-size-fits-all approach when it comes to uniform laws. We should carefully survey the legal landscape to determine the right fit for the territory based on size, available resources, and available service arrays. To do otherwise could unduly burden the system with requirements and mandates that may or may not be necessary. The Act itself, with the legislative comments, is 258 pages long. One would have to understand all aspects of what is covered in the Act, and even in my position as administrator, I cannot say that I do without further study. The resulting bill, number 350174, is 142 pages with no legislative notes on why some of the alternatives were chosen over others. I submit to this body that UG COPA came from careful study and evaluation, mostly as a result of the work of a task force or numerous task forces with comprehensive knowledge through membership, dedicated time and resources, expertise and experience in subject matter practice, and passionate leadership to guide the process to concise, beneficial, and tangible recommendations for meaningful change. I think more time is needed for thorough evaluation and informed decision-making prior to adoption. Thank you for the opportunity to provide this brief statement on Bill number 350174.
Thank you. Thank you. Now we would proceed with Attorney McKinney. Do you have a testimony to read?
Yes.
You may proceed.
Good evening, honorable members of the 35th Legislature. Again, I am here today in my capacity as chair of the VIBA Legislation and Law Reform Committee. The committee's goals are to review bills for efficiency and effectiveness, encourage stakeholder engagement, and provide input on potential human rights and public interest impacts. To note, these comments have not been reviewed or approved by the Virgin Islands Bar Association Board of Governors and do not necessarily reflect the views of the bar. Regarding Bill 350174, I would like to make technical and practical comments to aid in consideration and drafting of this bill, which will be provided as examples and other information below. Terms and phrases. Terms like substantial harm before appointing an emergency guardian may create unintended high bars to giving minors and adults in need an immediate guardian. Additionally, this specific provision states that must be likely to prevent substantial harm and that no other person appears to have authority and willingness to act in the circumstances. There may be a minor or adult who has no one to act on their behalf or take care of them, but who may not be in danger of substantial harm. There is a similar standard to this for conservatorships. Additionally, the bill states that an adult subject to guardianship or conservatorship shall be given by the court a notice that states, among other things, their right to be involved in decisions affecting them, including decisions about their care, dwelling, activities, or social activities, and their health care to the extent reasonably feasible. It may be helpful to analyze whether this term creates a high enough standard to ensure the individual is being involved in all decision-making to the extent possible, including by possibly replacing the term reasonably feasible with possible. Moreover, the definition of incapacitated person contains the term meet essential requirements in the phrase, to such an extent that the individual lacks the ability to meet essential requirements for physical health, safety, or self-care, even with appropriate technological assistance. This should be reviewed to ensure that it does not create a standard where the respondent must prove that they meet essential requirements and have capacity, as opposed to the petitioner being responsible for proving if they believe a person is incapacitated. Essential requirements may be able to be replaced with a term such as unable to meet physical health, safety, or self-care. Additionally, technical assistance should be updated to include supported decision-making, which includes assistance beyond technology. In general, terms similar to the above should be analyzed to ensure unintended standards are not created by the court, as the court needs to read meaning into every word the legislature passes in a bill. Rights of the respondent. Section 5310 requires that the judge state whether a person retains the right to vote and to marry and to provide findings and support in an order appointing a guardian. Other provisions also seem to state a guardian's ability to decide marriage, divorce, and annulment matters with court approval. However, it doesn't seem necessary that such determinations be required to be made in every order for guardianship, as these are rights that should not be removed ordinarily. It is suggested these provisions be reviewed and possibly removed, particularly for voting. However, if there are particular concerns for a specific case that respondent may be forced or tricked to marry, etc., then maybe the considerations come into play that court approval is needed or that guardian is responsible for ensuring the will of the respondent, etc. It was suggested by an attorney in the community that instead of requiring a statement of whether a person retains the right to vote or to marry, something to the extent of the individual retains all other civil rights granted as a citizen be written. There are sections about an adult subject to guardianship's dwelling and choices to move that individual. And those sections should be reviewed very carefully to ensure that a person, particularly older persons, can age in place if that is their will and to the extent possible. Provisions of the bill generally seem to state that termination of a guardianship or conservatorship occur upon death or order of the court. All provisions should be reviewed to ensure that 1, even with a guardianship, conservatorship, or protective arrangement, the individual is free to make their own decisions to the extent they are able, even accounting for that ability changing over time. And 2, that an individual is able to quickly terminate all or part of a guardianship, conservatorship, or protective arrangement if they are not an incapacitated individual. Notice, hearing, and petition provisions. There seems to be numerous provisions related to notices, in particular, in this bill for different types of guardianship and conservatorship hearings. There are also multiple hearing and petition provisions. These provisions should be reviewed to ensure they are all consistent, particularly regarding notice. It may be helpful to consolidate into 1 or 2 notice, petition, and hearing sections. For example, 1 for guardianships and 1 for conservatorships, to assist in consistency in reviewing. Additionally, some provisions require that several parties receive notice, but aside from usually requiring that the respondent actually receive notice, is a statement that says failure to give notice under this subsection does not preclude the court from appointing a guardian for seemingly all other parties. This includes adult children, persons caring for the adult, etc., not having to be served for the court to appoint a guardian. If certain relationships to that respondent are applicable, it may be important to require notice to these persons to ensure the best interest of the respondent is being considered by the judge. Moreover, when drafting a petition, the petitioner only needs to provide information regarding the reason a guardianship or conservatorship is being requested to the extent known. The reason for requesting a guardianship, conservatorship, or protective arrangement should be required information in the initial petition to preliminarily establish that there is a valid basis for the petition. Capacity. And I would just like to quickly add that after I submitted this, I spoke with a few attorneys, and it seems that currently there are visitors that are working under the current law. However, I premise that on what I'm going to say now. Under section 5304, appointment of a visitor is required to interview the respondent, which includes informing the respondent, interviewing the petitioner and proposed guardian, visiting the respondent's dwelling and potential dwelling, and filing a detailed report with the court. That includes, for example, recommendation for appointment of attorney for respondent, summary of self-care and independent living tasks respondent can manage without support, could manage with support, and cannot manage, appropriateness of a guardianship and whether a protective arrangement or other less restrictive alternative meets the respondent's needs, etc. However, it may not always be practical for the court to employ a visitor, especially in a timely manner. Therefore, it may be helpful to write alternatives to an appointment, such as allowing the judge to conduct the interview tasks, probably during a hearing, to request documentation, including pictures of living situations, etc., to include and also to include elements of a visitor's report in its decision or order. Additionally, it may be, pardon me. Additionally, it may be helpful to delete limiting sentences, such as that a visitor must be an individual with training or experience in the type of abilities, limitations, and needs alleged in the petition, to not further and unduly limit who may act as a visitor. Moreover, it may be helpful to add that a guardian ad litem can act as a visitor or that a visitor appointment is optional. It was pointed out to me by an attorney in the community that currently, sometimes a visitor and a guardian ad litem are both appointed in a case, and some of their duties may overlap, such as visiting the person's dwelling, and this may further strain limited resources. Additionally, the legislature should consider reviewing all instances where court approval is required to assess whether there are alternatives to court approval, which could take time and may hinder time-sensitive decisions, etc. Timing. The bill only allows for emergency guardian and conservators to be appointed for 60 days with one 60-day extension. This may cause additional judicial resources to be used to deal with an issue where an emergency guardian or conservatorship is needed beyond these timeframes, and may also cause additional vulnerability to the individual needing guardianship or conservatorship. This may occur even though the statute calls for a hearing within 5 days to determine the appropriateness of the appointment. Additionally, a provision of the bill seems to require that a guardian initiate a proceeding for a conservatorship or protective arrangement instead of conservatorship, if necessary to protect the individual's property. This may create an undue burden to the guardian, including of time and money. This could possibly be moved to Section 5-314A, which lists powers that a guardian may engage. The relevance of other statutes. Based on conversations with attorneys in the community, there may be other existing laws that should be reviewed in conjunction with this bill, such as existing laws regarding disabilities and child custody to ensure provisions, for example, definitions, are consistent. Additionally, it may be helpful to review the existing guardianship and conservatorship bill to ensure the provisions seen as hindering in the existing bill are addressed in the new bill. Stakeholders. It seems that further discussions with stakeholders may be helpful and can include sending the bill for review as well as general conversations and asking for feedback on their experiences with guardianships and conservatorships. The goal of this testimony was to provide examples and general technical and practical feedback for consideration when reviewing this bill as a whole. In addition to what has already been said, it may also be helpful to conduct research on the issues that individuals subject to guardianship and conservatorship have faced to ensure adequate safeguards are in place to protect their rights. I am happy to discuss my comments for this bill further, and I thank you very much for your time today.
Thank you, Attorney McKinney, for your testimony today, and I'd like to thank all who provided testimony today, virtual and in the chambers. This is the conclusion of the testimony, but it's not the conclusion of my colleagues asking questions. And I know it's Friday, but the Rules and Judiciary Committee, we have postponed this committee meeting time and time, and it just had to happen today. So forgive us that it's on a Friday, but the work must be done. So colleagues, I think I would begin with Senator Bolkis on the island of St. Thomas, who is one of the sponsors of this legislation. Senator, you may proceed with 4 minutes.
Thank you, Madam Chair. And I want to start off by commending the primary bill sponsor for the effort here concerning this bill 35-0174. And much of the testimony that has been provided to us today is not abruptly against the bill, but rather to sort of indicate what technical amendments are required for the bill to be sort of polished in the sense of being prepared to move forward to the next step. This is our good, healthy discussion, and it's important for us to understand, especially from the stakeholders and the individuals who are leaders in those sectors, for us to make sure that we make the proper revisions and amendments to this bill. And I want to say, I don't have any questions. However, I want to reiterate a number of things to include, push my position on the bill as well. And the act, it definitely repeals and replaces the Uniform Guardianship Protective Proceedings Act, and it emphasizes important provision, especially for our young people who may be displaced because of a number of reasons. And of course, the effort here is to make sure that that framework exists and that it is fair and conducted in a manner that has balance judgment in the sense of that. The Office of the Territorial Public Defender has highlighted that this will reduce expenses, increase accountability, and clarify rights. It aims to streamline the court process and thereby reducing backlogs and improving the efficiency of our judicial system. And we know that the backlogs in the judicial system are expansive. Most importantly, it provides, like I mentioned and has been mentioned throughout this hearing today, a comprehensive framework for handling these conservatorships and guardianships. Additionally, the bill introduces a significant measure to protect these minors and adults and mandates legal counsel to be appointed to minors and their parents' guardianship proceedings, and ensuring that they're fully informed and represented. That is a very important part of this process. A lot of people don't understand guardianship and conservatorship proceedings, and you need individuals to represent you in some cases. I know people have went into the courtroom. I know of some. I am also one of those individuals that has had to go into a courtroom not understanding conservatorship and guardianship. But luckily for me, I was able to retain someone that does. And in this case, this measure will help these individuals, whether they can afford it or not, to be able to have that counsel at their side to represent them as balanced as possible. We also want to ensure that
1 minute.
non-parties can file requests for notices and promote transparency and reducing potential conflicts. We know that this situation has a lot of mixed emotions and feelings, and sometimes frustrations get the best of us, especially when you're trying to do something that you don't fully understand. Again, creating this framework for those individuals to be able to get the help that they need to be represented properly is a win-win for me. And I'm very sure that the bill sponsor has been taking notes and making the recommendations that have been provided. And I'm very, very sure that those revisions will be made at the appropriate time moving forward. So I, as a sponsor as well, I definitely want to move forward with this provision and do whatever it takes to make sure that all of the amendments and changes have been made as suggested. Madam Chair, thank you for the time.
Thank you, Senator Bolkes. I just want to say that I understand the whole intention of this bill. I've actually had the opportunity to work for AARP, so I understand this bill as it pertains to the uniform guardianship and protecting proceedings. This bill actually just offers protection for the vulnerable population. And this is what we are here to do, to improve the quality of life for those individuals that can't help themselves. So I want to commend the bill sponsor. I just told the Senate President that, Senator, I signed on to your bill and I have some amendments because the bills that we bring when we have individuals come before us and we may not have thought about putting that in our bill, that is why we treasure your professional opinion, and I just want to say this is a protection that's well needed for the vulnerable population in the VI. Senator Potter, I think you are next. 4 minutes.
Thank you. Thank you so very much, Madam Chair. Good afternoon again, colleagues, and to the testifiers who are before us today. I too applaud the bill sponsor, and I too am in sync definitely with the intent of the legislation. I was a former director of the Division of Personnel, and we had oversight over the group health insurance program. I'm a member of the credit union, St. Thomas Federal Credit Union, and I have personally heard our stories of abuse of persons who are vulnerable, persons who are incapacitated, older adults being exploited for the pennies that they were saving over their lifetime, small pennies. And very often you're talking about people who you know, loved ones, in quotes, who are doing a lot of the exploitation. But my concern with the bill right now is I am not sure if it is right to move forward right now, particularly given the magnitude of this, of what we're trying to achieve. And I think we're whole scale deleting what is in existence now and creating a brand new law to replace what was there before. Two of the testifiers, Attorney McKinney, Attorney DeChabert, mentioned the need for us to pause just a minute to perhaps get additional input from stakeholders to ensure that when we move forward, we're able to move forward with a solid bill that can, sustain scrutiny, and will be not just a general bill, but something that is really relevant to us here in the territory. I wanted to ask Attorney Ozeski and Attorney Bolt in particular, is there value in us having a task force comprised of the subject matter experts and the stakeholders to break down the bill in pieces, offer their input and suggestions and their review, so that we can make sure that the bill does exactly what it is intended to do? Is there value, in your opinion, Attorney Ozeski, Attorney Volt, in us taking a little more time to review and fine-tune this bill?
I would say that there is
1 minute.
There is an opportunity here. We do have various groups that are part of the bench and the bar. We have the probate law committee, which I chair for the Virgin Islands Bar. You've got the legislation and law reform committee, which Attorney McKinney chairs. I think that we can, I think there are a number of things that Administrator Deshabert Peterson said, I think does bear some scrutiny. I think that we also, the delayed effective date, I think would help, the court clerks and the judges, the members of the bar to all have the opportunity to get continuing education on this. I think there are some opportunities here, but I think it can be worked out.
Attorney Ozeski on the chair stand.
Senator, you may conclude.
No, the question was posed to both Attorney Bolt and Attorney Ozeski, so I was just allowing him to put his comments on the record.
Sure.
Thank you, Senator. I'm happy to work with stakeholders to implement some of the changes. I think we heard some good ideas here at the hearing today that could be implemented without harming uniformity or the intent of the reforms that are included in the uniform law. As to the exact best way to do that, I have to defer to all of you in the Virgin Islands as to what the proper procedure is to get this done expeditiously so that we can improve the law. And remember that the people who are subject to it today can't wait forever for us to get this done. So I'm happy to work, however, is most expedient and efficient to get this bill with amended in order so that we can satisfy some of the concerns that were heard today.
Thank you very much for your comments. Thank you very much, Madam Chair, for the time. I won't abuse your generosity.
Senator Potter, you may continue if you have another burning question. You may proceed. As a vice chair, I give you that opportunity.
I appreciate that. Madam Chair. And as you are the vice chair of my committee, I will remember that. Remember that generosity. I wanted to ask really about, and I don't know how it works right now. I'm talking about training of persons who are, we all heard of the Britney Spears. I think that's the conservatorship issue that played out in front of the public for years, it seems. And I think that at some point the courts recognized the need to remove the conservatorship. Is there a process where persons who are granted conservatorship, is there a mechanism or something in the system where they are allowed to receive periodic training, or, is there some oversight that the court is engaged with or is empowered to do with regards to once the conservatorship is granted, is there a process of engagement between the judiciary and the conservators, or does it end once it is granted? The interaction with that person who's granted that highly responsible role.
Senator, with the chair's permission, I'll be happy to address that question.
Thank you. You may proceed.
Okay. Yes, included in this bill are several provisions to prevent the sort of situation that happened in the Britney Spears case and another more recent one, the Michael Oher case, who was featured in the movie The Blind Side. These were inappropriate conservatorships, and there are at least 3 stages where this could have been prevented under this current legislation. First of all, at the initial stage where the conservatorship, where there's a petition, it cannot be implemented without consulting with the person who's the subject of the conservatorship. That didn't happen in either the Spears or the Oher case. The judge went ahead and implemented it because there was no disagreement among the parties, but nobody asked the most important party who was there, and that was the person who was going to be subject to the conservatorship, whether they understood the terms and the consequences. That can't happen under this current law. Further, once the conservatorship is in place, this law places an explicit duty on the conservator, a continuing duty, to inform the court if any circumstances change such that the conservatorship is no longer needed or necessary. Moreover, the conservator or guardian has to file annual reports with the court, in which case they have to answer that question, whether any circumstances have changed and whether there's a need for continuation. And finally, there is an easy provision in here for anyone who has an interest in the subject of the conservatorship, an interest in their welfare, to petition the court for a review or for a review of the guardian or conservator's conduct to be sure that they are acting in accordance with the plan that they have filed with the court and copies to all of the person's loved ones, or whether they are not acting in accordance with their duties and with the plan, which is meant to give them a standard to which you can hold them accountable. So at every stage of the process, there's greater protection in this law than there would be under your current law.
Excellent. Thank you very much for your testimony. Thank you very much, testifiers, for your thoughtful comments on this very important piece of legislation. And thank you for your generosity, Madam Chair.
Thank you, Senator Potter, for your very important questions. I have a point of information from Senator Franklin Johnson. You may proceed.
Thank you very much, Madam Chair. I want to stay on this line of question because I want to ask Attorney Bolts and Orzinski if there's any part of this law here that would pretty much hold the guardians or conservatorship persons responsible, especially those who sometimes take their parents and drop them off to their hospital, leave them there, they become boarders now, but yet they're collecting the benefits. Is there anything in there that addresses that, and what do we need to do to pretty much address that? Because that is some of our problem that we are experiencing right now with some members that has a mother or father or family member has the responsibility through the courts, if I may say, but are not fulfilling the obligations by leaving them to the hospital and has them there as boarder. So if both of you, and then Ms. Benjamin, I'll let you chime in a bit to the end too on that, if you can. So we start with Ozinski and then Tom Bowles.
Thank you, Senator. I would call your attention, first of all, to Section 5313, which outlines the duties of a guardian for an adult. And there's a comparable section for the guardians of a minor. It requires the guardian to become and remain acquainted with the person who is the subject of their guardianship, to understand their needs, to involve them in their own decisions regarding their life. And then annually, under Section 317, to report to the court and disclose whether and how often they've been in contact with the person, what those person's needs are, any changes to their condition. So the the monitoring provisions, not only by the court, but by the community. This law allows the court to appoint loved ones of the person who's subject to guardianship, their family, their friends, anyone, maybe a relative who lives in the States and is not can't serve as guardian, but is in regular contact with them. They can name persons to receive copies of that report and the guardian's plan, and then verify that the guardian is in compliance with what they're supposed to be doing under the guardianship order. So yes, there are provisions to prevent the horrible situation you describe of neglect by guardians.
And you said the second section is 317?
5317, that's correct.
Okay, thank you.
I don't have anything to add. But I can say that Senator Johnson is quite correct. This is happening every day in the Virgin Islands, and but I believe that it would be addressed in this new legislation.
Thank you, Attorney Bolt. Senator Maurice James. Oh, you wanted to respond?
Well, I was asked to respond. Carla Benjamin, Assistant Commissioner, DHS. Admittedly, a bit outgunned by the attorneys. I haven't seen anything that would hold anyone who is legally responsible for the finances or anything of someone of whom they're a guardian responsible if they decided to not come pick them up from the hospital. A lot of times there's no previous indication that this person is in any way, or family members are in any way irresponsible, until we're presented with a situation where an elder or a disabled person is seriously ill and is then placed in the hospital, and for whatever reason, their discharge would mean an imposition, for lack of a better word, or additional increased responsibility for the person who's responsible for them, at which point they just disappear in terms of continuing to take responsibility. I haven't seen anything that would hold them responsible in the legislation.
I know I'm right before you, your next, Senator James, but Assistant Commissioner, so a person who's a boarder, say they receive Social Security benefits and they've been there a year, can the hospital not receive their Social Security check to cover whatever medical expenses they may be incurring? And that means the family member doesn't have control over those funds anymore?
What I can say is in instances where someone has a legal responsibility, legal fiduciary responsibility, report can be made to the Department of Human Services, Adult Protective Services, or possibly the AG's office, alleging misuse, so that misuse of the elders' funding or of the quote-unquote victims' funding, so that if they're the ones that are getting all the money and this person is in the hospital and is being neglected, there could possibly be a legal proceeding to determine that this person has misused the funds or to stop the misuse of funds. I don't know that the funding can be redirected to the hospital, and to my earlier point, to what extent they can be held responsible for doing for that person, other than stopping their ability to get the funds.
Thank you. Thank you. Senator Maurice James, you may proceed.
Thank you, Madam Chair. I find the answer interesting because I actually posed that exact question to the hospitals in a hearing. And the response that I got was that they work with the Department of Human Services to make sure that whatever money they can capture can be captured. I have to go back and look at that hearing because I asked that specific question when the hospital was talking about the fact that the uncompensated care and the borders. So I will revisit that hearing and look at that answer again. because the hospital would have to, in fact, notify someone, and I think it would be the Department of Human Services, right? And that they would work in sync. So anyway, that's something that we need to look into. Excellent question by my colleagues, both of you, because that was on my mind too. I do want to say that this bill is definitely a crucial step forward for the Virgin Islands. We don't necessarily have to be the followers of other states. Sometimes we can be the lead of other states, right? And some of the provisions that are very important to me are, for example, the involvement of non-parties, because it brings a valuable perspective to the court's attention when you know, that sometimes that otherwise overlooked, right? Also, it promotes a more person-centered approach as opposed to the old paternalistic way of doing things. We now look at the vulnerable population and we realize that they need to have a say in what happens to them. I do want to ask I have some other things that looking at the law that I liked, you know, the promotion of the least restrictive alternatives and just empowering people who otherwise, I think, in our society have not had a chance to have a say in their decisions. It promotes then the dignity and the autonomy that they need to have. So I know that the various testifiers provided input that I think is valuable, but I wanted to hone in on the Department of Human Services, just two areas that you talked about, Section 5204 with the attorney for minor or parent, and you're saying that you believe that the legal counsel should be appointed to minors and parents, even if they do not request representation. So are you saying that then we should just delete 1, 2, 3 and just make it so that the court shall appoint an attorney to represent a minor who is the subject of a proceeding under Section 5-202, and at that point have a period, delete 1, 2, 3? That's really what you're saying, right? We should put the period after 202 and then just eliminate, because I'm asking that because number 3 gives the court the right also to determine whether the minor needs representation. But all of these, A1, 2, and 3, require action on the part of the minor, the guardian ad litem, and the court. You're saying remove those 3 options and just have the court appoint an attorney, period. Correct?
Correct.
Okay. The other thing is, I don't know if was there a reason, Attorney Bolt, why, or I should ask, do you agree with the Department of Human Services that with respect to 5-204, that it should be mandatory that the court appoint an attorney to represent the minor, as opposed to the 3 avenues where the attorney can be appointed, and that's 5-204.
I'll yield to Ben Arzeski on that.
Time.
Okay.
Senator, the reason that provision is different, well, let me preface it by saying we would have no objection if the Senate chose to take that route. But under our laws, minors do not have unlimited rights. Their parents have rights on behalf of the minors. And so the section for guardianship for a minor does not make representation mandatory as the section for adults does. It leaves it subject to the will of the parent, who can request an attorney if they choose to do so on behalf of the minor.
Okay, did you understand what he was saying?
I understood what he was saying, but this section is effectively removing the parent's rights. There's a reason why the parent is being deemed not fully able to represent the child's best interest. So to expect them to then require representation, I don't think.
Yeah, do you, what do you say, sir, to that response? Because it is, the parent is not involved in 5-204. It's it's allowing the court to appoint a minor if the minor, the guardian ad litem, or the court. Doesn't say anything about the parent here in this section.
Yes, the section 204, I'm sorry, the attorney for minor or parent, is broader than simply the context where a guardianship hearing because a parent's rights are being terminated. There may be other reasons to appoint a guardian for a minor. For instance, a parent has been diagnosed as terminally ill. And so there's nothing wrong with the parent's behavior, but they're not going to be around, and they want to make sure that their child is legally cared for by somebody who has legal rights to do that after they're gone. Or a person is going to be detained in a penal system for an unrelated crime doesn't necessarily mean they're a bad parent and they should lose their rights, but there may be a need for a guardian. So for that situation, we are deferring to the parent in at least some cases. In the case that where a parent is being removed because their parental rights are being terminated, of course, their right to choose an attorney on behalf of the minor would also be terminated in that case, and it should be up to the court whether or not the minor is adequately represented or whether an attorney needs to be appointed to guard their interests.
What's the difference between section A and C, where it says the minor who is this? Oh, Madam Chair, I'm sorry. May I continue?
You may conclude.
A 5-204A and C. Doesn't
Senator C.
Go ahead.
Excuse me. I'm sorry.
No, go ahead, please.
C is a permissive provision, just clarifying that a minor may always retain an attorney to represent the minor if they choose to do so. A is a responsibility for the court to provide an attorney, whether or not the minor chooses to do so, and provides the conditions under which the court should do so.
Okay. You know, with legal language, you know, you read, and sometimes you interpret it a little different. I just have one more, Madam Chair, please.
You may proceed.
Yeah, that's 5-208, where, again, the Department of Human Services, you're objecting to every instance where the authority is given to the court to ensure that the minor is not being placed under the authority of an unsafe person or in a home with unsafe persons. I don't understand why you're objecting. I mean, what do you mean by without the associated requirements? I didn't understand that. I'm trying to understand why you're objecting, and then I have a suggestion that maybe will help. But why are you objecting to that?
Carla Benjamin, Assistant Commissioner, Department of Human Services. In this section, it says that the court has the authority to appoint an emergency guardian. Appointment of an emergency guardian is likely to prevent substantial harm to the minor's health, safety, and welfare. In child welfare, those are three very key terms. I don't see anything in here that requires the court to make any other determinations about the situation where that the child's going to be placed in. Emergency suggests immediacy. And I know from a child welfare perspective, if there's an emergency situation, and we're trying to safeguard a child, we have to see where the child is going to be, do background checks to make sure not only is the person who is going to be in charge of the child safe, but is there anyone in their household who is unsafe. There does not appear to be any parameters outside of the court can appoint someone if they determine that there might be substantial harm to the minor's health, safety, and welfare.
Would it help if maybe we added the Department of Human Services to receive reasonable notice under C and maybe even under D? Because I know D says without notice we could put except for the Department of Human Services, and then C insert Department of Human Services in one of the as one of the parties to receive notice. Would that help? So then you would know and appear at the hearing, I guess. I'm just trying to, I saw that objection and I said, well, maybe let's see if I can, if maybe my suggestion would help.
So I'm not sure if the intent behind this provision is to provide an alternative to the Department of Human Services having to act to ensure children's safety. Having Human Services present, I don't know if that would then ensure that the court is going to ask the Department of Human Services do these things that they usually do, which is follow up to make sure that the child is indeed safe. But I do believe, we do believe that there should be provisions in place to ensure that it's not just
the court?
In instances where the impetus or the circumstances create this need where it's health, safety, or welfare, there's more that needs to be done other than just appointing someone.
Okay. I would hope that the court, the judicial branch, would do as much as you would do, right, before they make a determination in finding the appointment of an emergency guard. But I'm an attorney, so I guess I may be in favor, I have a little bias towards attorneys and judges. So but I would hope that a family court judge would in fact do the necessary due diligence before placing a child or appointing an emergency guardian. However, I understand your concern. You want to make sure, and coming from the expertise and work that you do, I can understand your concern. So I do want to say though that I do support the bill. Clearly there's work to be done. And I appreciate the input that I've heard today. Thank you, Madam Chair, for your leniency.
Thank you, Senator James. You're going to make my other colleagues then want more time. It's okay. You asked some very important questions as it pertains to this bill. Senator Johnson, you may proceed with 4 minutes.
Good evening. Thank you very much. This was a very interesting conversation here today. And we spoke a little bit about Britney Spears. And I think the Virgin Islands have the case the opposite way. Most of our cases are not where the parents them is, the parents them are not the one trying to get the money from the children, but the children trying to get the money from the parents. So we pretty much have the reverse side of it here. And with the Britney Spears case, it was most of the concern was basically surrounding the financial benefits, and I'm here battling in my mind, and that's why my last question was about everyone who have guardianship or conservatorship over their parents, and then now just disappear from them and still collecting the money. And a lot of times, most of our borders are in that situation. Someone is collecting that check. And that's why I still try to pinpoint down to this, where and how do we address it in this measure to make sure that our elders are not just left there? Because many times that I've received calls where elders are left in the home, and then when you start checking, there is somebody responsible, at least in paper, on documents, in courts. So I'm trying to pin down, like, how do we address this concern? Because we're pretty much on the opposite end of it. We're not where most of our, and I would like Human Service to chime in to let me know if I'm correct, that most of our guardianship and conservatorship in the territory is most of the times children having that guardianship or conservatorship over their parents. Am I right to say that that's our bigger load of case in this territory?
You are correct.
And that's why I'm tackled with this. And when I was going through what the attorney told me to look through 13 and 17, and I was skimming through it, but I really don't see much there holding those people accountable for collecting those checks, but still neglecting the parents. So I really need to dig into that part a little bit more. And I would, appreciate if the attorney, not Bolts, the next gentleman, or says, can you help me with this a bit? I really want to chime down into this here. I need to hear a little bit more from you on that.
Yes, thank you, Senator Francis. The drafters of this Uniform Act deliberately did not try to draft a criminal statute. They wanted to draft a guardianship statute, but make clear that a guardian is a fiduciary. Legally, a fiduciary has the duty to act in the best interest of the person that they are representing. So if, in your example, a child who's guardian for their parent, they have to use the resources for the benefit of the parent and not for their own behalf. The way that we tried to clarify that is the first sentence of 5-313, where it says a guardian for an adult is a fiduciary. And that is the same in the section for conservator and for guardians for a minor. By imposing those fiduciary duties upon them, if they fail to act in the best interest of the person that they are supposed to be representing, then the drafters believed that existing criminal statutes would be appropriate to hold them responsible. So statute for fraud or misappropriation or neglect. Virgin Islands, I'm sure, in its criminal code already forbids this type of behavior. By making clear that a guardian is a fiduciary, those statutes should apply in a case where a person is neglecting their charge or misappropriating funds intended for their charge. Now, if that's not clear enough, I would have no objection to adding a reference to the Virgin Islands Criminal Code and saying that a fiduciary who fails to uphold their fiduciary duties could be subject to prosecution under Cite 2, whatever the appropriate law is in the Virgin Islands.
No, you're ringing now you're knocking right on my door. That's what I want to hear. and I do support the measure. I think, as we all indicate, that there's a little bit of work to do here with it to fine-tune it and make sure it addresses our need. And that's why I'm saying the Virgin Islands is a unique case, and it's on the opposite side of the spectrum when it comes to the guardianship and the conservatorship. So I definitely like the measure. I think we got a little bit of work to do. I don't know what the authors want to do, the sponsors, but I do support the measure. And I think we just got a little bit of work here to do to fine-tune it. It shouldn't take long, and I think that what you just recommend is I highly support. Thank you very much, Mr. Chair. Thank you.
Thank you, Senator from the West. Good afternoon.
Good afternoon.
You have a point of...
I did, sir.
You may proceed.
I just wanted to clarify that with the responses to Senator Johnson's questions, even the previous question, I want to reiterate that while there are criminal remedies, meaning someone can make a report saying that the guardian is misappropriating the funds or whatever, and charges can be filed for financial exploitation, nothing requires that they do anything to remove the person from the hospital, so they still remain a boarder.
Thank you. Thank you for that point of clarification there, because that's where I was gonna ask about how deep this goes to that end with regards to borders at the hospital. I think Mr. Schuster wanted to also reply to Senator Johnson's line of questioning.
Yes, thank you, Senator Gittens. So with regard to people who abandon or neglect their loved ones or the persons for whom they're responsible, we at AARP were working on a very comprehensive piece of anti-elder abuse legislation, and that's being taken into consideration there. And we're moving toward encouraging the legislature to make abandonment or neglect a felony. So we are addressing that in that piece of legislation. In California and some other states, it is a felony to abandon or neglect somebody that you have responsibility for. So I don't know that at AARP we would push to have that included in this piece of legislation. We do have a very comprehensive piece. Senator Bolkes is a sponsor. He has it in his hands. It's already well drafted. It's in legal counsel in the legislature right now. So, you know, we are addressing that in other ways. So we have taken that into consideration.
Thank you for that, Mr. Schuster. I believe it's my line of questioning, and I don't have much questions, but I do have one. But I want to I want to first say thank you to the bill sponsors for bringing this measure forward. And I am willing to support anything that further protects our elders or seniors in the community. So I welcome this Uniform Guardianship and Protective Proceedings Act for us today. But again, I don't have much questions, but I must come from off on the sidelines to ask Human Services, while we're looking at further protecting our seniors, what is the status of payments to the entities that are responsible for going out to some of these same elders that we're talking about, their homes, to assist with cleaning, feeding, etc. For instance, and I don't usually like to use particular names, but my office has been receiving a lot of calls from, I think it's a entity called Heavenly Homes or something, that's just saying that they have not been paid for quite some time. What's the status on the payments to these companies?
We have received some of those same complaints. I do not have an answer for you. I would have to get back to you on that, specifically because I don't have oversight of that tract, so I don't have the specific knowledge to say, well, the payments are awaiting disbursement or whatever, but I can get back to you.
Understood. I will just ask that you, as Assistant Commissioner, please assist us feverishly in getting payments to them. I don't believe that these entities should be treated as normal vendors or whatever. I mean, because of the critical service that they provide to our elders in this community. All right? I got this up to, I mean, besides the calls last night, and I'm not saying this to say I am bothered, because I like when people walk up to me at the gas station, at the supermarket, or wherever I am. But up to last night in the supermarket, I couldn't move from one aisle to the next without at least 2 people approaching me and asking me about this. So I'm really concerned about that. And while we're having this conversation, I want to ask you to personally look into that. And if there is any hiccups that we need to get involved, you don't work for us, but if we need to be of assistance, please reach out to one of us. Thank you. I believe that this concludes Senator Blyden. You're recognized for 4 minutes.
Thank you so much, Mr. Chair, and good evening to everyone. And I first want to thank the major sponsor, Senator Novel Francis, for bringing this most impactful, comprehensive piece of legislation. And I want to thank the testifiers again for their recommendations and suggestions in terms of amendment and other stuff that will strengthen the bill. But I want to speak to the bill itself, Bill number 35.0174, the Uniform Guardianship, Conservatorship, and Other Protective Amendments Act. And this critically important legislation updates existing uniform guardianship legislation in a way that will make a tremendous difference in the quality of life for seniors and other people under guardianship in the territory. In addition to already existing protections and structures, the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act places special emphasis on two areas that I believe to be vitally important. One, maximizing independence and preventing social isolation. Protecting a person's financial assets is critically important, but by itself, it is not enough to promote and ensure the well-being of persons under guardianship. Their emotional and other human needs and interests must be safeguarded as well. This bill really moves the needle forward in terms of how we take care of our elders and of all those in our community who need assistance in taking care of their affairs. Among other things, though, this bill mandates that guardians and conservators must, to the greatest practical extent, ensure that persons under guardianship have a role in making decisions about their lives. Additionally, it ensures that family members and other loved ones have access to and can maintain contact with persons under guardianship. I cannot begin to state how important this is for our elders and other folks here in the territory. Of all the things that people suffer with, old age and infirmity or disability, the loss of independence and loss of social contact are perhaps the hardest to endure, and they have a very real impact on a person's health and overall well-being. The need to feel a sense of control over one's destiny and the need to experience social contact are among our most powerful needs as human beings. But this legislation, in addition to strengthening and redefining the financial and legal structures and safeguards for persons under guardianship, breaks new ground by addressing non-financial needs. This is why I am proud to join with Senate President Francis and Senator Boquez, our at-large senator, as sponsors on this most important, impactful piece of legislation. And I know, as I stated, no bill is perfect. But I ask my colleagues, I cannot vote in this committee, but I ask my colleagues to support this most important measure because it will make a big difference on the lives of many individuals here in the territory. So I know we have work to do. I look forward to further discussion as the bill moves forward through the different committee. Again, thank you so much, Mr. Chair, for the time.
Thank you, Senator Blyden, for your line of questioning. Now we'll have prime sponsor of the bill to wrap up this last round of questioning. Senator Francis, you may proceed. 4 minutes.
Thank you very much, Madam Chair. And with the amount of people that's in this committee that's signing on in this bill, I don't see no reason why you can't move on today. And then we could address some of the concerns that have been raised. But I really want to thank my colleagues as well as the testifiers. Again, they brought some significant perspective for us to consider as we move this legislation forward. And I want to take this opportunity as well to commend the work of the Department of Human Services. I don't believe that they hear that often enough, and they have the responsibility of taking on from cradle to grave, in reality, and for perfect strangers, individuals that they don't know when family members go south on them. They have the responsibility then to step in and take on this awesome responsibility, and I really want to commend them because it can't be an easy task. It can't be an easy task, and I often ask them, how are they taking care of their own behavioral health? Because this is a lot for them to take on. This community, we heard the numbers when we talk about Asian community and a lot that's happening in this community, and I really want to commend them. But we have a real life situation occurring here. And every time we delay moving critical legislation forward, is justice delayed, is justice denied. So I believe that we have the stakeholders that have certainly brought the information to light. We have the testimonies that we could use then to go back and address some of the edits that's required here. And my colleague just said there's no perfect bill, and that's the reality of it. Even though when we move this bill with all of the necessary edits, there'll still be an opportunity for us to be able to make amendments in the future. Hence why we, that we always see the need to amend bills as we move forward to provide some consistency. But we can't handcuff the victims. We have real life situations that's occurring every time we go out there. We hear the stories, we live the stories, we know some of the stories that's occurring out there in terms of our young children, in terms of our seniors in this community. Justice delayed is justice denied. And I just ask my colleagues to work to move this measure forward. Real quickly, I wanted to ask you, Attorney Wazinski, because I know that you certainly have put a lot of work into this measure and will continue to work on it. But I wanted to ask you a point that was made by the Judiciary. They talk about the fact that the former bill, which by the way was moved by Senator Janet Millen Young back in the 31st legislature, Nellie O'Reilly, Justin Harrigan, and Samuel Sanes in Act 7958, Bill number 31-0184, the Judiciary had some concerns about the fact that the previous legislation, the Judiciary had a lot more discretion in terms of the determinations of the court-appointed legal representation. How do you respond to that?
Thank you, Senator. The administrator correctly pointed out that there are two alternatives in the Uniform Act. The bill that's before you selected Alternative B, which makes representation mandatory. The drafters of the Uniform Act believe that Alternative B represented the right policy, that everybody who is subject to a hearing for guardianship and might have their rights taken away deserve legal representation. However, they were also realistic enough to know that some states were never going to implement a law that required appointment of attorneys for the indigent. And so they listed Alternative A as an alternative, so it would allow this bill to be implemented, even though that might not be the ideal policy. You could get the rest of the good policies in there. So that's a long way of saying that if Alternative A is the only acceptable way to get this bill adopted in the U.S. Virgin Islands, we could substitute in Alternative A. We still think that Alternative B represents the better policy, that everybody should be represented by an attorney in court.
Very well. Thank you for that. And Madam Chair, if I may just wrap up.
Yes, you may.
2 quick points. The other issue I think that was very made clear by the administrator is the fact that we have a limited number of individuals. We have a capacity issue in terms of the availability of attorneys. I think she may have mentioned either 6 or 9 that sits that they're able to refer some of these cases to. So, with the magnitude and number of cases that we're seeing, I know that individuals are becoming overwhelmed. And even in instances where with legal services, I do a lot of work with legal services as well, where there is a limited number of available attorneys to support these endeavors, and we're even talking about how do we incentivize them to be able to represent the indigent community. Those that have money, they get good representation, but those vulnerable situation and those indigent is the one that's continue to be challenged by this. So again, we don't want to wait until individuals are within their crisis mode. I think it's being very critical, and I appreciate the comments made by Attorney Bolt that we need to make sure that we're marketing this, that we're educating, and individuals understand their rights and responsibilities, so that we could make sure that they're aware of what's available to them and not wait until they're in crisis mode in order for them to be able to get some assistance. So we have to do everything possible to mitigate them from getting into that crisis mode. It's been a long day. This has been a long discussion today, and I ask my colleagues to move this on to the next step, and we will do the heavy lifting that's required now to make sure that all of those suggested amendments, edits, or whatever that's in will rest on the shoulders of the stakeholders here, RP, Attorney Bolt, as well as Attorney Ozeski and my office, Shauna Richards, my researcher, so that we could get these amendments taken care of. Thank you very much, Madam Chair, for the time and opportunity.
Thank you, Senator Francis, prime sponsor of this legislation. I just have to say, for me, it's yes for potential reduction of crime. I say yes for accountability. So, do I hear a motion? Do I hear a motion?
Motion.
St. Thomas. Senator Bolkus, you are recognized for your motion.
Thank you, Madam Chair. Madam Chair, I move Bill number 35-0174, an act repealing and reenacting Title 15 Virgin Islands Code, Article 5, Parts 1, 2, 3, 4, enacting Part 5, and renumbering Part 4A as Part 6, to repeal the Uniform Guardianship and Protective Proceedings Act and enact the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act with amendments and for other related purposes, be favorably voted upon in this committee and reported out to the full body for further action and consideration. I so move.
Motion properly made by Senator Angel Bolkus, seconded by Senator Maurice James, seconded by Senator Kenneth Gittins, seconded also by Senator Franklin Johnson. Did I also hear a second on St. Thomas from Senator Potter?
Yes, second.
Yes. So hearing that, Bill number 35-0174, an act repealing and reenacting Title 15 Virgin Islands Code, Article 5, Parts 1, 2, 3, 4, enacting Part 5 and renumbering Part 4A as Part 6 to repeal the Uniform Guardianship and Protective Proceedings Act and enact the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act with amendments, no amendments, and other related purposes has been voted upon favorably by this Committee of Rules and Judiciary and will be reported out of this committee to the full body for further consideration. Oh, I am so sorry. It's a Friday. It's after 6. I didn't even do my roll call. No, even not, no lunch even. My lunch day over there. Roll call on the motion. I am so sorry.
Senator Angel L. Bolkus Jr.
Yeah.
Senator Bolkus Jr. Yay.
Yeah.
Senator Diane T. Capehart.
Yes.
Senator Capehart yay. Senator Kenneth L. Gittins. Senator Gittins yay. Senator Maurice C. James. Senator James yay. Senator Franklin D. Johnson. Senator Johnson yay. Senator Carla J. Joseph. Senator Joseph absent. Senator Milton E. Potter.
Yes.
Senator Potter yay. Madam Chair, you have 6 yeas, 1 absent.
Thank you, Madam Clerk. Bill number 35-0174, an act repealing and reenacting Title 15 Virgin Islands Code, Article 5, Parts 1, 2, 3, and 4, enacting Part 5 and renumbering Part 4A as Part 6 to repeal the Uniform Guardianship and Protective Proceedings Act and enact the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act and other related purposes has been voted upon favorably by the Committee on Rules and Judiciary and will be reported out of this committee to the full body for full consideration. At this time, I will ask all of the testifiers to provide a quick 30 seconds wrap up, starting with State Director Schuster, AARP. You may proceed.
Yes, thank you. Thank you, Senator Capehart. As you mentioned, yes, you worked for AARP. It was a great pleasure having you with us, but now it's an even greater pleasure having you there in the legislature as our advocate and partner and our champion. So I'm so happy that you still have the heart of AARP within you. Thank you again, Senator Capehart. And thanks to so many other people, the sponsoring senators, Francis and Bolkes and Blyden, for bringing this forward. A very special thank you to Attorney Benjamin Orzeski. AARP does a lot of work with the Uniform Law Commission all over the United States. And we meet here in the Virgin Islands, we meet with Attorney Orzeski on a regular basis. And we're really honored that whenever we call on him, he is willing to testify on these bills. We don't know how lucky we are that we have the Chief Legal Counsel of the Uniform Law Commission testifying right here in the Virgin Islands, virtually, but still with us. And of course, Attorney Tom Bolt, another great champion, Commissioner of the Uniform Law Commission, and so many others. And then when I saw my dear cousin, Regina Deshabir, going to testify, and I read her testimony, I said, oh my goodness, what an opponent. We need to make sure that she is in line with us. So Regina, great to see you, my cousin, and we look forward to working on these amendments with you as well. And thank you to all the other senators who voted in the affirmative. So I'm happy we got this forward and look forward to making the necessary amendments before it comes to the full body. Thanks again.
Thank you, Mr. Schuster, AARP, for all of the 50-plus generation that AARP advocate for. Thank you. Let's have Attorney Bolt. 30 seconds, please.
Thank you so much for this opportunity to have come before the Committee on Rules and Judiciary. I pledge the support of the Uniform Law Commission with regard to working with counsel's office to provide for the amendments that have been requested, and we'll have those ready for floor consideration. I thank you one and all and look forward to appearing in the future.
Thank you. Attorney Ben Orzeski, you may proceed. 30 seconds, please.
Thank you. I'd just like to thank the committee for its consideration, for its thoughtful questions, and for your important action to advance this this legislation today. I want to echo Director Schuster's. I also value the strong relationship between AARP and the Uniform Law Commission and the achievements we've been able to work on together. I look forward to working with all the stakeholders to amend this bill so that it gets into a form that everyone can support and enact for the United States Virgin Islands. Thank you.
Thank you. Thank you for your very impactful testimony today. I'll have Assistant Commissioner Carla Benjamin.
Well, I'd like to offer thanks again to the Senator for bringing this important legislation forward. It's well needed, well supported, and the Department of Human Services fully supports with the revisions that have been discussed, moving this very important legislation forward. Thank you for inviting us to testify.
Thank you. Attorney McKinney.
Good evening, Attorney Jessica McKinney, Chair of the Legislation and Law Reform Committee. Before I say a quick statement, could I please answer a question that was asked earlier about institutions receiving money?
Sure, you may proceed.
One of the provisions state that owners and operators, employees of institutions may not be granted guardianship or conservatorship unless they are related by blood, adoption. I did some quick research to try to understand why that would have even been in there, and apparently some institutions may try and go and get conservatorship or guardianship in order to be able to get funds or control to allow someone to be able to stay in an institution and continue to be taken care of instead of being discharged. So I just wanted to provide context that I had seen when I had also looked into that. You know, if something like that was going to be further looked into, it would also, you know, it may also be helpful to look into how that could help people in the community that are needing those services, but also to prevent abuse or, you know, being somewhere that they shouldn't be. For my statement, I would just like to say that words matter, especially when written in the law. So it may be helpful to review terms for meaning, review all the provisions for consistency, and to clearly and to make sure that intentions of the bill are clearly stated to allow them to be followed the way that they were intended by the court and the other parties.
Thank you. Thank you for that
very much.
information. We'll have the Administrator of Courts, Regina DeChavere Peterson. You may proceed, 30 seconds.
Thank you, Madam Chairperson. As always, it is always a pleasure, and we're forever grateful for every opportunity to provide input on important legislation affecting our territory and our citizens. And for my dear cousin, never an opponent, always a partner in making sure that when we do these comprehensive adoptions of legislation, that we are able to successfully implement in a manner that it works.
Very good.
Thank you. Colleagues, this, as mentioned before, no bill is perfect, but we didn't want to hold the process up because this bill is very important. And I look forward to seeing amendments, because I do have some amendments towards this bill that I have already spoken to the bill sponsor about. And I look forward to having further discussion in session on this bill. So at this time, we'll take a quick 2-minute recess. The Committee on Rules and Judiciary is hereby in recess.
The Virgin Islands Department of Human Services cares deeply about our community, and it shows through the direct services we provide daily to our constituents, which includes your mother, father, grandparents.
Recess. Colleagues, we are now in Block 4. We have 3 bills that has already been vetted in the Committee of Jurisdiction. Colleagues, we are going to have 3 minutes, 1 minute each on each bill, starting with sponsor. Who is the sponsor of Bill number 35-0030? Please proceed.
Thank you very much, Madam Chair. Madam Chair and colleagues, Bill number 35-0030 was heard in the Committee of Government Operations, Consumer Protection, and Veterans Affairs on March 26. It was both heartwarming and humbling to hear Vaughn Akibeka family, Benjamin's family, friends, and bandmates speak so highly about his life and his legacy of contributions to reggae music and our community. Vaughn, along with his brother Ronnie and the Midnight Band, released their first album in 1997 to international acclaim, and over 25 years became renowned around the world for their deep and spiritual lyrics and trademark sound. Vaughn's evolution as a person and a musician continued when he took the name Akibeka, which was also the name of his new band. Vaughn Andre Benjamin was a lifelong learner, an avid reader, a prolific writer and poet. He was a spiritual leader and teacher to many Rastafarians' faith and a global icon in the Rastafarian music movement. This is a posthumous award because we did not give Vaughn Akibeka his flowers while he was here to receive them. This bill also provides for the design of a monument and for the naming of the waterfront park west of Marley Homes, the Vaughn Akibeka Memorial Park. I ask for my colleagues' support on this measure. Again, I'm not a member of this committee, but I ask for their support in recognizing the contributions that have been made by this individual, Vaughn Akibeka Benjamin. Thank you very much, Madam Chair, for the time.
Thank you, Senator Francis. Who speaks on Bill number 35-15?
I do, Madam Chair.
Please proceed.
Thank you. Madam Chair, I ask for the support of my colleagues. As you know, Bill number 35-0215 was originally heard in the Committee of Jurisdiction, the Public Safety Committee. The bill was unanimously passed through that committee. What the bill does is it's pretty straightforward. It increases the term of a firearm license from 3 years to 5 years. As a general rule, colleagues, you know persons possessing licensed firearms are law-abiding citizens who take the responsibility of holding a firearm license very seriously. Increasing the term of firearm licensure from 3 years to 5 years will enhance efficiency by reducing the administrative burden on both license holders as well as the Virgin Islands Police Department, while maintaining stringent monitoring protocols to ensure responsible firearm ownership. The fee structure will not be affected by the 2-year extension of time. While, as you know, the $150 that is charged right now, which is codified, was recently implemented by the Virgin Islands Police Department. While I'm not a member of the committee, well, scratch that. I am respectfully asking for your support of this initiative. Additionally, I met with Commissioner Ray Martinez, who asked that we provide an amendment, which I will be presenting here today. Also, the amendment requires a firearms safety course be taken prior to the expiration of the 5-year term. As you know, right now, The only thing that is required is for you to have that safety course initially when you are pursuing your firearm license. Once you've received that firearm license, for renewal, there's no longer a requirement. There's no requirement right now for you to get that firearm, test that firearm, have some training. That doesn't exist right now. So this amendment really, I think, adds to the whole safety of the firearm ownership, and that during the course of that 5-year period, you're also going to be required to have a firearm safety course. So at the appropriate time, Madam Chair, I'm going to ask all of my colleagues for their support on this initiative. Thank you very much.
Who speaks on bill number 350238?
I do, Madam Chair.
You may proceed.
Thank you. Good evening, colleagues. And as you know, this initiative was also heard in the Committee of Jurisdiction. It was vetted. It was supported by the presenters, all the testifiers, the government employees, retirement system, as well as the Assistant Police Commissioner on behalf of Ray Martinez, Mr. Sidney Elsko. The bill really, again, is straightforward. It grants peace officer status to police officers or enforcement officers, rather, who are employed by the government employees retirement system. As you know, that area has approximately 1 million passengers who traverse, passengers as well as locals who traverse that area on an annual basis. Over the last couple of years, we've witnessed a spate of serious crimes committed at that area. GRS has asked that to ensure that as part of their vision for Crown Bay, granting peace officer status to a cadre of their safety personnel would enable them to complete the requisite peace officer training via the Virgin Islands Police Academy. These officers would have the authority to respond to emergencies quickly, to enforce the laws, and to maintain order at the Haven site mall premises, thereby deterring criminal activity and ensuring a peaceful environment for both locals and visitors. Having peace officers on site will enhance the overall reputation of the mall as a safe and secure destination, potentially attracting even more visitors and boosting the local economy. As I mentioned, both the Virgin Islands Police Department as well as the government employees retirement system were supportive of this initiative. Madam Chair, colleagues, I respectfully ask you for your support on this very important piece of legislation. And thank you very much.
Thank you, Senator Potter. Colleagues, this now starts the beginning of our 3-minute, I can't even say debate time, but just your debate time on the 3 bills that we have before us. They have already been vetted in the Committee of Jurisdiction. This is the clearinghouse of these bills. So I will allow colleagues 3 minutes to talk about all 3 bills in this block, starting with Senator Bulkhead's 3 minutes.
Thank you, Madam Chair. Madam Chair, I'm supporting all of these measures in this block. 35-0215, which amends Virgin Islands Code to extend the firearm licenses from 3 years to 5, extending those licenses reduces administrative burden, both on firearm owners and the licensing authorities, and the renewal period, which streamlines the process to save time and resources and make it more convenient for law-abiding citizens to maintain their licenses. And also the bill carefully maintains the current term for the 24-hour concealed licenses, ensuring that the appropriate regulatory oversight is still preserved. Bill number 350238, which confers peace officer status on qualified law enforcement employees of the government employee retirement system, is a step towards enhancing the security and integrity of those individuals who are protecting one of our economic jewels here in the Virgin Islands, specifically in St. Thomas, the Haven site area. We know that there's been a cluster of different activities that have happened there in the past. And if we had law enforcement officers there, perhaps they would have been able to be diffused more quickly. So I believe that this is a public safety measure as well that will definitely be beneficial in the long run. And as for bill number 35-0030, commending Von Benjamin, better known as Aki Becker, for his immense contributions to the Virgin Islands through reggae music and, of course, cultural heritage. It proposes the construction of a monument in his honor, and Von Benjamin was a global icon whose music and spiritual teachings left an indelible mark on not only this territory, but the world. And his work through Midnight Band and other collaborations brought international acclaim to the Virgin Islands, and his lyrics inspired countless individuals with messages of peace, justice, African liberation, and spirituality. And by passing this, we continue to inspire future generations of the contributions that he left here, and he will never be forgotten for them. So I urge all my colleagues to support this measure and all of the other measures in this block. Thank you, Madam Chair.
Thank you, Senator Bolkes. Senator Novell Francis, you may proceed.
Thank you very much, Madam Chair. I've already spoken on bill number 35-0030, again, an act honoring and commending Von Benjamin. In addition to that, there's an appropriation of $45,000, which will be for the monument naming the waterfront park west of Marley Homes, Devon Aki Becker Memorial Park. I want to thank my co-sponsors on this particular measure, Senator Angel Bolkes, Senator Carla Joseph, and Senator Samuel Carrion, for supporting me in this endeavor, where we again recognizing the contribution that have been made by this individual, Von Aki Becker Benjamin. In respect to bill number 35-0215, I had the opportunity to further discuss this matter with the bill sponsor, where the extension of the terms for registration of the firearms from 3 years to 5 years comes at no additional cost and really is a benefit to the applicant or the licensee. Of course, being a former police commissioner myself, I'm just a little bit concerned in that instance where a lot of time you're able to gauge the ownership of those firearms by being able to do that 3-year inspection. And now it'll take them almost 5 years to make a determination whether or not that firearm is still in that person's possession or not. But that's not a major issue at this point. Of course, we're talking about law-abiding citizens that register in their firearms. So I will be supporting that measure at the appropriate time, not being a member of this committee. I continue to have some reservations in regards to the GRS retirement system actually having law enforcement just to control the mall. Obviously, when you confer peace officer status to individuals, that peace officer status goes with them everywhere they go, territory wide, and it's not just for the mall area. How far are we going to take this? Are we going to put security at Sunny House, Sunshine Mall, Niski Shopping Center? I think we need to be extremely careful with precedent setting that will, be problematic in the future. So I'll continue to contemplate that decision in regards to that particular peace officer status. There's a great responsibility that comes with that peace officer status, and accountability that comes with it. We know that if the issue, and I've created other peace officers in other institutions as well, UVI, the hospital, here at the legislature. But of course, those are institutions that continue to exist, and they know of their responsibility that comes with them every single where they go. I continue to hear of just the testifiers and the proponent to speak about the fact that they will have peace officer status at that location at the mall. For me, that's not where it stops. It goes a long way beyond that, and I'm not sure that they're could appreciate what they're asking for in this instance. Of course, if they want security at the mall, then they should have all right to do that. They petition the Virgin Islands Police Department and be able to get armed security for the level of protection that they'll need at the mall, if that's exactly what they're trying to achieve by this. Thank you very much for your time, Madam Chair.
Thank you, Senator Francis. Senator Maurice James, you may proceed. 3 minutes.
Thank you, Madam Chair. With respect to the 3 bills, I am going to defer to the expertise of my fellow colleagues with law enforcement background, and I will vote affirmatively for 35-0215, even though I still, I'm not sure, it seems counterintuitive in this time of high crime rates that we're experiencing to extend the time for someone to have an additional 2 years and not know whether or not they should be entitled to it. But because the sponsor listened and inserted the refresher course or training certificate, I can support that. And with respect to 238, I'm still not convinced, based on my discussions with, as I said, colleagues who understand law enforcement and security, whether or not this is a measure that I can support at this time without further understanding of the need for it when it can be addressed in a different manner. Of course, with respect to 35-0030, I am in full support. I knew Von Benjamin always was very inspired by his presence and his beautiful smile all the time, and of course his music. So I definitely support the Von Benjamin Monument, and I commend the sponsors for that. Thank you, Madam Chair.
Thank you, Senator James. Senator Gittins, you may proceed. 3 minutes.
Thank you, Madam Chair, and good evening to all. I do support a majority of the measures in this block, namely the act honoring and commending Von Benjamin posthumously, and the act amending the VA code relating to the contents of a firearm license to change the statement in the license, increasing the term of the license from 3 to 5 years. However, Bill number 35-0238 to grant the mall, again, I do not support granting peace officer status to a non-government entity. I am not sure if the GRS truly understands the liability that comes with such a responsibility. This designation of peace officer is for public employees. The employees that this bill seeks to designate or grant peace officer status to are employees of an independent quasi-agency of the government of the Virgin Islands. The GRS justification for this measure is mainly the safety and security of the mall. And I could not agree more that shoppers in a mall should be comfortable and feel rather safe in their surroundings. But the general public is not the GRS's concern. Again, it's the safety and well-being of the mall. Peace officer is a designation for law enforcement officers with the authority to detain and arrest persons accused of violating the law. In the last hearing of the Committee of Jurisdiction on May 14th, I listed over 15 public agencies that already have this designation. The mall nor its security personnel is not a public entity. Again, it's an independent quasi-agency of the government of the Virgin Islands. Why not continue to use the designation of security officers and just have some trained, certified, and authorized as armed security officers? Besides cameras, an effective deterrence of crime is the presence of a uniformed security officer. Sadly, because of current day dress attire, we can't even identify our police officers today. The mere difference in the duties and responsibilities between, and if I may conclude here, Madam Chair.
Yes, you may.
The mere differences, rather, in the duties and responsibilities between law enforcement officers and security officers is that law enforcement officers are committed to protecting the public at large, while the security officers are entrusted to protect the interest of their client and property, namely the GRS mall. In addition to the increased cost of this measure, is the GRS ready to take on this liability? My vote remains no on this measure. Thank you, Madam Chair.
Thank you, Senator Gittins. Colleagues, bill number 350030. This, I am so happy that the sponsor brought this bill, because not only the Rastafarian community will be happy, the people of Frederiksted, the people of St. Croix, the people of the Virgin Islands, who took pride in knowing that Midnight Band was from St. Croix, and the music traveled all throughout the world. So I am in support of that legislation. I'm not in the committee for Senator Gittins, but I know these bills went through 350215 and 350238. I have concerns with 350238, which I actually had a conversation with the bill's sponsor. So at this time, I have reservations as I'm hearing concerns, valid concerns about this legislation. So at this time, if
point of information.
At this time, colleagues, I would entertain a motion. Is that what you wanted to do, Senator Bolkes?
Point of information.
Oh, points of information. You may proceed.
Thank you, Madam Chair. And also, I don't believe that Senator Potter had an opportunity, but for my point of information, I know that there is some sort of reluctancy, and I wanted to clarify for the record a number of things. This measure is not for the mall, it's for GERS. And in addition to that, there are other instrumentalities such as the Virgin Islands Port Authority, the University of the Virgin Islands, who are not directly departments and agencies of the government of the Virgin Islands. However, they do have officers that went through the post program. So I wanted to make sure that that is on the record so that we understand clearly that those things are not factual. And that's all for my point of information for this time.
Thank you, Senator Bolkes. Senator Potter, please forgive me. You may proceed with your 3 minutes. as the bill sponsor. Please forgive me.
Forgive me, Madam Chair. Madam Chair, I rise in support of all the measures in this block, this final block. Of course, we all know Vaughn Benjamin, prolific writer and performer of the great Midnight Band. As I always say, as Virgin Islanders, we have a responsibility to big up, to support, and to honor our own when they achieve excellence. And Vaughn Benjamin, without question, is very deserving of this accolade and having the design and construction of a monument in his honor. I think that is an awesome thing. So kudos to sponsors of that initiative. Bill number 35-0125, the firearm extension bill. The bill allows for the extension of the firearm license from 3 years to 5 years. And what it also does is that it institutes a mandatory training, refresher for individuals. Right now, as the law exists, you can have a firearm license. 20 years ago, when you first got your license, there was a requirement that you go to the training. You go through that process. After that, for subsequent renewals, there is no such requirement. So this bill really brings a touch of safety in that it allows and requires an additional training for persons who possess the firearm license. We know that persons who are firearm owners typically are law-abiding citizens, and this gives them an opportunity to have their license extended to a 5-year period, and it creates a more streamlined process with regards to the renewal of their license, and it allows for the extra layer of safety when it comes to the 5-year renewal period. Bill number 35-0238, as you know, the principles of the Government Employees Retirement System, the Dawson, as well as their enforcement chief were there, as well as VIPD Assistant Commissioner on behalf of Commissioner Martinez, the top law enforcement official in the territory. They were fully on board with this initiative.
Time.
Madam Chair, if I may just wrap up.
You may wrap up.
They were fully on board with it. It is a part of their strategy. As you know, we've had a number of very serious crimes that occurred at the Havenside Mall. Had we had law enforcement personnel there with peace officer status, perhaps the outcomes would have been different. It's no different than the Virgin Islands Port Authority having enforcement personnel there, as well as the University of the Virgin Islands. These folks have training. They are going to be required to go through the Virgin Islands Police Academy, which is different than having armed security guards, you know, someone who just has a gun. This is more than that. We're saying we want trained, armed security personnel who have peace officer status, so they go through the intensive training at the Virgin Islands Police Department Training Academy. This independent instrumentality, they are saying, look, this is what we would like. It is in our best interest. Over 1 million persons traverse the mall area on an annual basis, more so than any other space in this territory. Colleagues, it is in our best interest to go along with this, to support this very important initiative. It is part of their GRS's strategic plan. I respectfully ask you all for your support of this initiative. Thank you very much, Madam Chair, for your generosity.
Thank you, Senator Potter. Do I hear a motion on bill number 350030?
Motion.
Motion, Senator Bolkes.
Thank you, Madam Chair. Madam Chair, I move bill number 35-0030, an act honoring and commending Von Benjamin posthumously for his contributions to reggae music in the Virgin Islands and the global communities, appropriating $45,000 to the Department of Sports, Parks, and Recreation for the design and construction of the Von Benjamin Monument and naming the waterfront park west of the Marley homes the Von Akibeka Memorial Park. Be favorably voted upon in this committee and reported out to the full body for further action and consideration. I so move.
Second.
Motion properly made by Senator Angel Bolkes and seconded by Senator Potter, seconded by Senator Maurice James, seconded by Senator Gittins. Roll call on bill number 35-0030.
Senator Angel L. Bolkes Jr.
Yay.
Senator Bolkes, yay. Senator Kenneth L. Gittins. Senator Gittins, yay. Senator Maurice C. James.
Yes.
Senator James, yay. Senator Franklin D. Johnson. Senator Johnson, absent. Senator Carla J. Joseph. Senator Joseph, absent. Senator Milton E. Potter.
Yes.
Senator Potter, yay. Senator Diane T. Capehart.
Yes.
Senator Capehart, yay. Madam Chair, you have 5 yeas, 2 absent.
Thank you, Madam Clerk. Bill number 35-0030, an act honoring and commending Von Benjamin posthumously for his contributions to reggae music in the Virgin Islands and the global communities, appropriating $45,000 to the Department of Sports, Parks, and Recreation for the design and construction of the Von Benjamin Monument and naming the waterfront park west of Marley Homes, the Von Akabeka Memorial Park, has been voted upon favorably by this Committee of Rules and Judiciary and will be reported out of the full body for full consideration. Do I hear a motion on bill number 35-0215?
Amendment.
Amendment, Senator Potter, you may proceed.
Thank you very much, Madam Chair. Madam Chair, I offer amendment number 35-777 to bill number 35-0215. Bill number 35-0215 is amended by striking Section 1 and inserting the following. Section 1, Title 23, Virgin Islands Code, Chapter 5 is amended as follows. 1, in Section 455B, second sentence after $150, insert a certificate of completion.
Motion.
Motion, Senator Gittins.
Thank you. Colleagues, I move to waive the reading of amendment number 35, that's 777. I so move.
Second.
Properly moved and seconded by Senator Maurice James and Senator Bolkes. Hearing no objection, so ordered.
Motion.
Motion, Senator. I so move. Oh, you need to say I so move.
I so move.
I so move.
And seconded by, motion made by Senator Potter, seconded by Senator Gittins. Hearing no objections, so ordered. Roll call on the order. On the bill as amended.
Yeah, right.
Roll call on the bill as amended.
Amended.
Senator Angel L. Bolkes Jr.
Yay. Yay.
Yes. Allow me. Senator Potter, please proceed with your motion so we can dispose of the bill.
Thank you, Madam Chair. Thank you. I move that Bill number 35-0215, an act amending Title 23 Virgin Islands Code, Chapter 5, Section 457, subsection A, Paragraph 3, relating to the contents of a firearm license to change the statement in the license, increasing the term of the license from 3 years to 5 years, as amended, be favorably voted upon in the Committee of Rules and Judiciary and forwarded to the full body for further consideration and action. I so move.
Second.
Properly moved by Senator Potter, seconded by Senator Bolkes, as amended. Roll call on the motion.
Senator Angel L. Bolkes Jr.
Yay.
Senator Bolkes, yay. Senator Kenneth L. Gittins. Yes. Senator Gittins, yay. Senator Maurice C. James.
No?
Senator,
Yes? Yes.
Senator James, yay. Senator Franklin D. Johnson. Senator Johnson, absent. Senator Carla J. Joseph. Senator Joseph, absent. Senator Milton E. Potter.
Yes.
Senator Potter, yay. Senator Diane T. Capehart.
Yes.
Senator Capehart, yay. Madam Chair, you have 5 yeas, 2 absent.
Bill number 35-0215 as amended, an act amending Title 23 Virgin Islands Code, Chapter 5, Section 457, subsection A, Paragraph 3, related to the contents of a firearm license to change the statement in the license, increasing the term of the license from 3 years to 5 years, has been voted upon favorably by the Committee on Rules and Judiciary and will be reported out of this committee for full consideration. Do I hear a motion for Bill number 35-0238?
Motion.
Motion, Senator Potter.
Thank you very much, Madam Chair. I move that Bill number 35-0238, an act to confer peace officer status on qualified enforcement officers employed by the Government Employees Retirement System of the Virgin Islands, be favorably voted upon in a Committee on Rules and Judiciary and forwarded to the full body for further consideration and action. I so move.
Second.
Motion properly made by Senator Potter and seconded by Senator Bolkes. Objection, Senator Gittins. Roll call.
Senator Angel L. Bolkes Jr.
Yay.
Senator Bolkes Jr., yay. Senator Kenneth L. Gittins.
No.
Senator Gittins, nay. Senator Maurice C. James.
No.
Senator James, nay. Senator Franklin D. Johnson. Senator Johnson, absent. Senator Carla J. Joseph. Senator Joseph, absent. Senator Milton E. Potter.
Yes.
Senator Potter, yay. Senator Diane T. Capehart.
No.
Senator Capehart, nay. Madam Chair, you have 2 yeas, 3 nays, 2 absent.
The motion fails. Bill number 35-0238, an act to confer peace officer status on qualified enforcement officers employed by the Government Employees Retirement System of the Virgin Islands, measure failed upon by this Committee on Rules and Judiciary and will be reported out to the full body. No? Failed. Has failed, period. Colleagues, it's been a long day. We have concluded 4 blocks. I want to say thank you to my colleagues. I want to say thank you to the legislative staff. I want to say Thank you to media. Condolences again to the Pamela Richards family and to the McIntosh family. As I said this in my my opening remarks, and congratulations to all the graduates. Happy Memorial Weekend. God bless the Virgin Islands, and thank you for my staff. This meeting of Rules and Judiciary is hereby adjourned.